Okay. Oh, so, we don't need to do this. Yeah.
All rise, please. The 13th Circuit Court for the County of Antrim is now in session. The Honorable Charles Hammond presiding.
Thank you. Let's go back on the record.
Yeah.
Let's go back on the record. File 22-5165-FH. We're back. It's Monday morning. Continued trial. Mr. Ralston and team are here from the Attorney General's office. Defendants are all appearing in person with their respective counsel. The jury is still outside of the courtroom. Folks are all here. Mr. Ralston, let me start with you. Anything that you need to discuss before bringing the jury back?
No, Your Honor, none of you have to be here.
Mr. Nunzi?
Yes, thank you, Your Honor. At this time, Your Honor, we believe that the prosecutor has overstepped their bounds with respect to the potential class of victims in this case without sufficient notice. The felony information doesn't say anything about the Elm City Rapids Police Department, law enforcement in general, the governor's detail of the Michigan State Police in connection with this case. And so what they've done is they have bootstrapped this other class of victims to the charges against the defendants in this case. That is providing material support to commit an act of terrorism as well as the felony firearm charge. And they have not noticed the court with respect to 404B, and that specifically goes to prior bad acts and contemporaneous bad acts. But it also includes victim conduct or other potential victim conduct that we see in criminal sexual conduct cases, where they're expanding the class of victims, not putting us on notice that we had the opportunity to rebut their other class of victims, that being law enforcement, as I've indicated before. The court has denied a request for a bill of particulars, and we seek in our bill of particulars, as granted by the court in other cases, any potential victims and or witnesses unknown to the defense so that we can prepare for a trial, prepare for an evidentiary hearing. So these other victims are mentioned in the felony information. They have now been bootstrapped to this case, strategically so, because what they're doing is they're drawing law enforcement in as potential victims to obviously seek the sympathy of the jury with respect to a law enforcement rich community, so to speak. And we've seen that in the jury questionnaire, so there's a lot of law enforcement connections. So strategically they're doing that, however, they can't do it because it violates, we believe, the court rules with respect to notice, and quite frankly, it's not noticed in the felony information. So what we're requesting is that the court prohibit the prosecution from using these other potential class of victims, bootstrapping it to the charges against the defendants. And we're requesting a curative instruction from the court saying that and an immediate curative instruction, letting the jury know that the defendants are not charged with material support to commit an act of terrorism against these other class of victims, that of law enforcement in general, the Elm City Rapids Police Department, the governor's detail, which are literally police officers, and the Michigan State Police. It would be unfair to violation of due process, and it's a violation at this point, I think, of the right to confront without proper notice. So we respectfully request the court to move in that fashion. Thank you very much.
Mr. Seiler?
Yes, sir. We would concur with Mr. Nunzio's oral motion. We'd ask that there be declared mistrial. Thank you.
Mr. Brennan?
We would, join your the counsel, so to put up some points here. If you would like to have a sidebar before we bring the jury on, totally independent issue, to perhaps change your judgment. So as a courtesy to the prosecution.
Mr. Nunzio has a request for mistrial. You go.
If the court is going to give a curative instruction, then we would not join that request for mistrial. But if the court's not going to give that, then it gives the prosecution carte blanche to continue with these other class of victims. Unfortunately, portraying our clients in a worse manner without notification. So, without a period of instruction, we would join Mr. Cyrus' motion. With a period of instruction, we would withdraw that request.
Mr. Wilson, what are we going to do?
Well, Judge, I don't believe the governor's listed in our information. I mean, I don't think he creates a requirement that doesn't exist in that we didn't list, particular victims of a crime. So I think he's creating an obligation where none exists. The idea of a mistrial, there's no manifest necessity here. I'd ask the court to resist the request for a curative instruction. I'm not sure even what it would say. At this point, so understanding that there's no obligation to list a victim within the information is kind of where I would start. And then where I would also go to a couple of things. Number one, the witness list that we filed, clearly showed that we were going to be calling Scott McManus, and who's the first lieutenant in charge of the governor's protection detail, and Dave Centella. The facts of this case have been known for years. Mr. Centella lived 3 doors south of the governor. He's been referenced in testimony before. The discoveries included that information as well. So there's no surprise here is what I'm trying to say. And I see no reason for a curative instruction. And again, I'm not even sure what it would say. So I'm a little bit of a loss in terms of what Mr. Nunzio is proposing.
If I may. Sure. It opens the door, without a curative instruction, opens up the door with respect to material support for charges with law enforcement. That now, we did it 1 year in this case, Your Honor. It was clearly identified by the prosecution regarding the governor with respect to her being the victim. You can't infer victim status. She's either the victim of the case or she's not the victim of the case. If she's not on the witness list, then why are we talking about the governor? Now, I understand how they're doing that, through third-party testimony making her a victim, but it conflates the issues and it's confusing. And does it now is counsel not duty bound to cross-examine witnesses with respect to material support for terrorism with all these other folks? I say not because we were not placed on notice. Surprise is not an element of the 404 notice. It is notification. They're duty bound to let us know. It is not what's in police reports. It's not by way of surprise. It's statutorily required 14 days prior to trial that 404 notice be listed with respect to other potential victims regarding exactly for what it is: plan, scheme, design, motive, or intent, which is the structural background of all this, that they planned, they schemed, they designed. And so naming these other victims, I think, conflates the issues and confuses the issues, and it's a violation of due process because we're not on notice of that. And I think it would, unfortunately, cause confusion within the jury if we're now talking about material support with these other individuals. When clearly the case is centered around Governor Richard Whitmer. So we would stand on our original motion.
Just very briefly, with no bill of particulars, the witness list doesn't mean anything to us. Witness list is a witness list. It doesn't put us on notice that there are the alleged victims or anything like that. Secondly, more importantly, we ran a motion about 2-3 months ago in the court to preclude the prosecution from prosecuting this case because their client is named as a potential victim in the case. This court ruled that they weren't pursuing this case on behalf of Dana Nessel, so they were going to be allowed to proceed. They were only pursuing this case on behalf of Governor Richard Whitmer. That right there will lock in our victim class. Mr. Nunzio is 100% correct. This violates 404B. I'm asking for a mistrial. Mr. Nunzio is asking for an alternative for a curative instruction. Either way, we're both asking for the prosecution not to even touch that line again, not make law enforcement alleged victim. Thank you.
Mr. Martin?
Thank you, Your Honor. The point's well made about the prior motion that actually Mr. Cyber did in district court as well. We the victims were they two people, or the attorney general, governor. And it was a right line test, just the governor. I'm concerned because the jury was displayed under their pick who the victim was. And there's one person, we're going to throw in Scott McManus now, who's well known in Indian County. Michigan State Police Trooper, ski patrol person who grew up there. It's like, he's lived here. Then obviously be added as a victim. That's a huge quantity from just the doctor and others that might be less of the practice police officer. Chief of police, whatever. It's like this fact. And others. So they've expanded. Fix that, and I'm sure I'm just going to join Mr. Cyber with his request at this point. We've asked the court to try to figure out a way to unravel this because the jury was told something very clearly. I'm going to do well with that. I'm concerned about, but I did go through the question. You know, through the names, we've not done anything, so let's portray that and make a difference to a jury. Thank you.
Mr. Olson, anything else?
I don't think 404B applies, Judge, because the fact, 404B applies where we have a separate fact and circumstance, a separate set of facts over here from another event. And then we want to use that to show intent, motive, scheme, planning in the case at issue. And the reason that doesn't exist in this case is because the governor's protection detail and what they were going to do to anybody who responded is part of the facts in this case. Does the court have any questions? Thank you.
Mr. Nunzio, anything else?
No, thank you, Your Honor.
Mr. Cyber?
No, thank you, Your Honor.
Mr. Barnett?
No, you're right.
Okay, we're going to take a short break so I can take a look at some stuff, but I wanted you want to decide our side.
Yes, sir. I would. Okay.
We'll be in recess for a short time. Thank you. Thank you. You can be seated. Before we get to the motions that were made, I just want to let the parties know we did receive a note from the jury. It just indicates, can we please have the air conditioning put on, humid and stuffy, please. We are working on that. Just back to the issue at hand. What's been brought up by the defense is an issue relative to what's been labeled as an expansion of the class of victims in this case, or an expansion beyond the issue really at hand. Mr. Nunzio originally made that motion, requested that the court issue a curative instruction. Mr. Cyber, with the same basis for the motion, moved for a mistrial, and then if I'm characterizing Mr. Nunzio's position correctly, if the curative instruction is not given by the court, then he would be in favor in requesting a mistrial. And then Mr. Barnett has joined in that request as well. So there's wide number of things to cover there. The first thing that was brought up was the motion for a bill of particulars that was denied by the court. That was done several weeks ago, I want to say at this point. And the request there, the genesis of that was to better identify which of the definitions under the definition of material support applied in this case. And there was also a motion that was mentioned to exclude the Attorney General's office from being able to prosecute this case because, as was supplied to the court, I think it was 2 separate FBI reports in which I guess the way I would phrase it is disparaging comments were made about the Attorney General by several folks in chat groups or things along those lines. And then the argument was that she would potentially be a witness, which means that their office would not be able to handle this. And, you know, these cases, all trials are very interesting in the sense that the judge generally finds out about facts of the case with the jury. You know, in this case, I have a leg up on them, so to speak, in that there has been pretty extensive motion practice in this case, whether it's the motions to quash, so I've reviewed the transcripts from the preliminary exam, or some of the other motions, a couple that have been mentioned today. So I do know a little bit more than they might. And generally, when we refer to this, I think it's been referred to as, you know, the plot to kidnap the governor, or things along those lines. It's the sort of general tone. And that's the broad brush that has been painted of this case. But obviously, what goes along with that is a much more specific set of circumstances. And I would note the offense in this case is not kidnapping or attempted kidnapping. Count 1, which is the genesis of this argument in the court's mind, is providing material support for a terrorist act. The count 1 reads, did knowingly provide material support or resources to a terrorist or terrorist organization to be used in whole or in part to plan, prepare, carry out, facilitate, or avoid apprehension for committing an act of terrorism against the United States or its citizens, this state or its citizens, or a political subdivision, or any other instrumentality of this state or of a local unit of government. Contrary to NCL 750.543K, parens 1, parens lowercase b. Now, as you know, there are also definitions of what constitutes material support that are provided in separate statute. And as I've indicated previously, when we've had other motions made regarding relevancy, for example, the court has said that there's a wide spectrum of what applies to this case. And that certainly the discussion is not lost here. And I would note that while I don't mean to imply that this is not a victim crime or things along those lines, the governor's name was not mentioned in the account that I just read. Her name does not appear on the felony information where it says victim or complainant, as we might see. You know, the example I've always used is a retail fraud when I've made analogies. In this case, the criminal sexual conduct case is the one that was referenced here. And the difference in this case and that analogy is for 404, what we most commonly see in a CSC case would be you're here for an incident that occurred on day X. There are allegations that it happened on Y, Z, whatever it may be. 404 motion is done or notice, and then the court determines. Now, there are special statutes that apply to sexual assault cases too that come into play for this analogy, but you're bringing in those other acts. As I have noted, with the wide spectrum of this case, they're not other acts. They're the facts of this case. They're the acts that constitute the allegations for the wide spectrum of behavior that has been classified. And as to the specific request and some of the notes that were made by the attorneys, my understanding from some of the testimony that we've had is that 3 different locations were potentially picked to be targets, that being the governor's mansion on Mackinac Island, that being, I think it was for residents in or the capital, maybe in Lansing, and then also the vacation home here in Antrim County. The testimony, as I understood it, for the reason why the vacation home was the one selected was because it was thought that would have lighter security measures in place. But certainly that would mean that there are still security measures in place. I also think it's a logical deduction that the governor of any state, let alone the state of Michigan, would have security detail or security personnel following her or him or with that individual at all times. At least that would have been the logical assumption of me. Additionally, part of the allegations in this case, in terms of the act itself, the incident by which if there's going to be a boat or a launch where they go from the boat launch to the house, take her, or whatever it may be, the discussion, as I've understood it again, is that the bridge in Elk Rapids would be attacked. And the idea was that that would slow down law enforcement's response because Elk Rapids is the closest police department local unit that would be able to respond. So again, that's the case. I don't find anything surprising part of that. And I think that, again, if the attack would be there, and it's logical to assume, or logically follows at least, that the security detail would be attacked, it would be that any law enforcement would be attacked as well. So I don't find that there's any undue surprise or anything along those lines, or unfair advantage or violation of due process that occurred. The other thing that was mentioned or brought up was 404, and I discussed a little bit today, and I discussed it already previously, that in the court's mind it does not constitute other acts because they're the acts or the facts of this case. And so 404 is not implicated at all. It's simply a discussion of relevance. And as was even noted in Kidnapping, which is the really seminal case for other acts, a logically relevant act is admissible, even when the finding of logical relevance requires a long chain of intervening inferences. There are other cases in the Michigan Supreme Court or the Court of Appeals that indicate that the threshold for relevancy is minimal. Any tendency is sufficient probative force. Evidence is relevant if it is material and has probative value. Materiality is the requirement that the proffered evidence be related to any fact that is of consequence to the action. Evidence has probative value when it tends to make the existence of any fact that is of consequence to the determination of the action more or less probable than it would be without the evidence. I also note too that the relationship of the elements of the charge, the theories of admissibility, and the defense's asserted governs what is relevant and material. A material fact need not be an element of a crime or a cause of action or defense, but it must always be an issue in the sense that it is within the range of litigated matters in controversy. Materiality does not mean that the evidence must be directed at an element of a crime or a defense. And so as I've indicated, the information and the evidence in this case is vast. There's nothing wrong with that per se. Does the evidence have any tendency to aid the jury to find a fact in this case in determining, for example, the knowledge that these three defendants had as part of this plan that has been outlined, so that they can determine whether they provided material support? Yes, in the court's mind it does. And so all of that evidence, as has been previously determined and outlined, is relevant for reasons that I stated today and previously. They're the facts of the case, and so not other acts. I don't believe 404 is implicated. Also, as to a mistrial, that is necessary when manifest necessity is reached. There may be several circumstances under which that becomes reached in the case. The most common, I think, is the way that I would phrase that, or the most frequent that we see is if a jury cannot reach a verdict, for example, then a mistrial is declared, and then the parties can decide what to do from there. This is a little different. It's based on evidentiary issues, but the requirement is still the same. And based on the rulings that I've made, I don't believe, or I will not find, that there has been a manifest necessity. I will find that none such exists. So the request for a mistrial is also denied. Mr. Ralston, anything to keep before we bring the jury back?
No, sir.
Mr. Nuns, anything else for you? Mr. Saga? Mr. Barnett?
No, Your Honor, thank you.
Okay, all rise for the jury. All right, everyone, you can see it. Thank you. So, ladies and gentlemen, welcome back. I'll talk about your note in just a moment, but I was checking with folks. Anything that anyone needs to report from the weekend based on restrictions. Okay. The other thing I want to let you know, we did get your note, and I love historic buildings, I have to say, but modern HVAC would be a very nice thing at times. We are working with the maintenance department to try to improve things, just to know that proper those new best.
We did good.
Okay. But we are still going to work on that, just with the obviously a little lower at 6. If you recall, when we left off on Friday, we're still in the prosecution's case in chief, still located in Midland, testifying. So with that, Mr. Ralston.
Good morning, Judge.
And ladies and gentlemen, as I indicated previously, I was restoring this. If you go before you sit down, you raise your hand. You swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth.
I do.
Go ahead and your seat. Mr. Ralston.
Thank you, Judge. Good morning.
Good morning.
When we left off on Friday, we were talking about some different communications with Mr. Fox and other individuals. I'd like to come back to that and focus your attention, if we could, on the 1st of August. And tell us, if you will, is there an item on our significant events timeline, if you look at number 13 there, that indicates a meeting on that date?
Yes. So from the significant events timeline, number 13 is the Recon Roundtable, which is a meeting in Belleville at Sean Fix's residence.
Okay, and remind the jury, please, who Sean Fix is.
Sean Fix is Adam Fox's XO, so executive officer or second in charge.
Okay, and who attended that meeting?
Adam Fox, Amanda Keller, Sean Fix, and Undercover Mark attended the meeting.
Okay, and was their meeting recorded in some way?
Yes, it was.
And the content, are you familiar with the proposed exhibit 115?
Yes.
And can you tell us briefly what that audio clip talks about?
So this is a conversation between Sean Fix, Adam Fox, and Amanda Keller. Undercover Mark is present. It's a discussion about who's going to be provided as personnel for the attack plans moving forward. Adam Fox lists out who's part of the plan, and he lists Eric Molitor.
Move for admission of proposed exhibit 115, please, and the
Mr. Sauer.
Judge, we respect to stand on there.
Mr. Ryan.
You've got, is this 115?
yes, and I should also inquire of the witness, is there an associated transcript marked 115T?
Yes.
Okay, does that transcript accurately reflect the audio content?
Yes.
I'd move for admission of both 115 and 115T, please.
Mr. Nunn, Mr. Stiver, I assume same position, bro.
That's correct.
Yes.
Okay, Mr. Barnett, that's both.
I have 115 in my book that's been provided to me by the Attorney General's office. And there's a title to this. Molitor, but I couldn't read here. I don't see Mr. Wilson.
No, I just wanted to make sure you were looking at the same thing as the exhibit.
There's no Molitor listed below. It's titled refers to a name, his name, but it doesn't include the statement, so I just reject there, just identifying whatever they're trying to put in here. It's not 115, but that's
I think what council refers to is,
If you could approach
Sure.
the attorneys and if you could bring copies. Let's go back on the record. Think the objection will be overruled in 115, 115.
thank you, Judge.
I apologize, Your Honor.
Oh, yeah.
Just for the record, we do not object, Your Honor. Stress, don't mind, it's not really-
Thanks. Oh, yeah, thank you, Adam. Agent Impla, there's some accounting going on there. Is that correct?
Yes, sir.
And what's being tallied?
Adam Fox is counting members of his team who he can rely on for the attack.
Okay. And at the first paragraph, there's an indication of the founding meeting. What's that a reference to?
That's the new Founding Fathers meeting in Dublin, Ohio from June 6th.
Okay. All right. Let's move to proposed exhibit 116. Are you familiar with that?
Yes, I am.
And can you describe what it is, please?
Sure. This is a recording of a phone call between CHS Dan and Adam Fox. It's from August 4th, 2020.
Okay. And briefly describe the content of that phone call.
Adam Fox tells CHS Dan his philosophy on leadership, how he feels it's best to lead by example, and how he feels like he's putting forth his example for the team.
And is there an associated transcript marked 116T that accompanies that audio and does it reflect the content of the audio?
Yes, sir.
Move for admission proposed 116 and 116T, please.
Mr. Mender?
Okay.
Mr. Sire?
Stand in the objection.
Mr. Barnett?
No.
Both will be.
Okay. proposed exhibit 117. You familiar with that, Agent Impler?
I am.
Can you tell us what that is?
This is a 3-page exhibit, and these are text messages between Bill Null and Adam Fox, and they were found on Bill Null's cell phone.
Okay. Did you have a search warrant in order to look at that?
Yes, sir.
Okay. And when did this exchange occur?
It was on August 9th, 2020.
And tell us generally what the exchange talks about.
Bill Null is talking about training, getting together in the future, and meeting in person at another time.
Okay. Move for admission of proposed exhibit 117, please.
Mr. Manager?
No comment.
Mr. Sadler?
Please stand on the objections.
Mr. Ryan?
No objection.
You're waiting.
Can you describe, Agent Implo, what we're seeing here?
Sure. So on the left side, the green here, this is Bill Null's text message. And the blue here is Adam Fox's text message. And these are left to right and top to bottom, left to right.
On the left, on the bottom, whose text message is that for the record?
This is Adam Fox on the left, and this is Bill Null on the right.
Okay. Can you zoom in up on the, thank you, on the upper left? And again, Agent Employer, remind us the date of this exchange.
I'm sorry, I said 8/9, and but this text thread actually started on July 22nd. You can see it down here.
Understood. And if you can read that into the record, please.
Sure. Bill Null stated, "Yeah, I hear that. Just keep setting brush fires and hoping the blaze will start."
How does Adam Fox respond to that proposition?
His reply is, "Yeah, buddy."
In terms of setting the brush fires and hoping the blaze will start, what does that refer to?
Objection, speculation. Unless there's foundation for it, Your Honor.
I think given Agent Impla's knowledge and depth on the case, Judge, he should be allowed to offer his thoughts on that. It would certainly be relevant.
The witness's personal knowledge that showed it, but he's going to speculate as to an answer that's misleading to the jury.
I think the text message speaks for themselves.
Thank you.
Okay. Can you go to the bottom left there and tell us what we're seeing?
So this is a text message from Adam Fox to Bill Null, and this is from August 9th, 2020.
Okay. And read the message into the record, please.
Hi, what's up, bro?
Does Mr. Fox respond? I'm sorry, does Mr. Bill Null respond to Mr. Fox's inquiry?
Yes, he does. So same day, August 9th, 2020, Bill Null replies, "I'm in the UP, brother. I'll hit you up when I get back in town."
Okay. How many pages are on this exhibit?
3 pages.
Okay. And can you go, thank you, Adam, the response by Mr. Fox to that statement by Mr. Bill Null?
Copy.
And if you can, move to the next one, please, Adam. We see, what are we seeing here, Agent Impel?
So this is a text message from Bill Null. It's August 10th, 2020. So the next day, Bill Null stated, "Hey, brother, I'm back in town. I'd like to set up a time to chat with you about some cross groups training and some other shit that's going on."
Okay. Does Mr. Adam Fox respond to that?
He does.
What does he say?
Adam Fox says, for sure. And we have our FTX here September 12th to 13th too. That's later in the day on August 10th, 2020.
And then does Mr. Fox have an additional comment to Mr. Bill Knoll at that point?
Yes. On the same day, August 10th, 2020, Adam Fox states, it's going to be epic, bro, bringing people together.
Okay. The reference in that message before this one to the September 12th and 13th date, what does that refer to?
That's the national training exercise in Luther, Michigan on Ty Garvin's property set up by the Wolverine Watchmen.
Okay. Can you go to the third page there, please? And who is this message from?
This is Adam Fox to Bill Knoll on August 10th, 2020.
And what does the message say?
It says, got some MHG actually coming.
What is MHG? Are you familiar with that acronym?
Yes,
What is it?
it's Michigan Home Guard. It's the largest militia in Michigan.
Okay. And does Mr. Bill Knoll have a response to that?
He does.
And can you read that into the record?
Sure. So from August 10th, 2020, Bill Knoll stated, fuck yeah, man, I'll get some guys together that actually train. And you got some free time this week to talk in person, like Wednesday or Thursday?
Okay. We saw messages earlier last week, I should say, and you mentioned operational security, correct?
Yes, sir.
Are in-person meetings part of operational security?
Absolutely.
Why?
Because you can talk securely without any electronic devices so that the government can't obtain evidence against you.
Okay. And if we can move to the next message, please, Adam. Does Mr. Fox have a response to Mr. Bill Knoll's statement that he wants to meet in person?
Yes, he does.
Go ahead and read that into the record, please.
So on August 10th, 2020, Adam Fox stated, we can make it happen. I got kicked out of reps, though. Didn't know why even. Some shit about people complaining, saying I was intimidating while working out. You believe that shit? Jerry's a bitch, bro.
What's reps?
Adam Fox's gym.
Okay. And does he make is there a continuing statement by Mr. Fox in the lower right-hand box there?
There is.
What does it say? Read that into the record, please.
Adam Fox stated, but we can make it happen, brother.
In reference to Mr. Bill Knoll's request for a face-to-face meeting, correct?
Yes, sir.
Okay. All right. I'd like to move forward in time, if we could, to the 9th of August, 2020. Tell us, if you will, is that, was there something happening in Munith down in Jackson County on that date?
Yes, sir.
And tell the jury a little bit about that.
There was a field training exercise in Jackson County set up by the Wolverine Watchmen that Adam Fox was invited to. This was a continuation of the group training that the Wolverine Watchmen did on June 28th with Adam Fox. So this is the second time Adam Fox went to Munith to combine forces with the Wolverine Watchmen.
Okay, and is there an associated transcript? Or rather, are you familiar with Exhibit 118?
I am.
And generally describe what that is, please.
This is a discussion outside Joe Morrison's Munith property on August 9th, in which Adam Fox and members of the Wolverine Watchmen discussed the kidnapping plot, the need to perform recon for an attack with smaller teams.
And how was it obtained?
It was obtained via recording from CHS Dan, who was present at the meeting.
Okay, and is there associated transcript marked 118T?
Yes.
Okay, and does that transcript accurately reflect the audio that's in 118?
Yes.
I'm going to move for admission, please, of proposed exhibits 118 and 118T.
Mr. Seiler.
Please stand up. Objection.
Okay.
Okay, both will be admitted.
And then before you start that, I have a few comments. I'm sorry. Can you remind the jurors who Morrison is?
Sure. Joe Morrison from our subjects of investigation chart.
Thank you.
So he's on the bottom left of the subjects of investigation chart. He's the founder of the Wolverine Watchmen.
And Mr. Moray?
Mr. Moray, Mike Moray, is not on the list here on the subjects of investigation chart, but he is a militia member that Adam Fox recruited at one of the rallies.
All right. Thank you, Adam. If you play that, please.
When I started out, we had somebody, I got the word on the internet, we got a lot more intel. Small, water guys that are coming through up here. They don't want to take my extra people, who take it and fall off this year. You do this, listen, I am, are you on board? Yeah. That won't shoot up the thing, then we'll remove the funding for our diet. So we need to be very careful how we do it. What we do is our costs on rules on there. And now we don't want to. We don't want to go the wrong way. How else can we put out a positive image that we're not doing this about there? So we're doing it. We got some scramble on this. Get up the whole interesting, dude. We always get going. Once the rebound comes back, I don't know, maybe 8. 7, 8 months. 8 months. No more than 8. So we're going to do too many. Start to worry about too many guys and boots on ground and so.
The number of people, the 8-man team, what is that in reference to?
That's in reference to the attack team that would be assaulting the governor's cabin.
Okay. And remind the jury who Mr. Ty Garbin is again?
The Ty Garbin, AKA Gunny. He's top right of the subjects of investigation. So he's one of the founding members of the Wolverine Watchmen. And he's the owner of the property in Luther, Michigan, where they did the training.
All right. Are you familiar with proposed exhibit 119?
I've got the record reflect that the witness wanted to rechart. As part of this testimony.
It's exhibit 1, the subjects of the investigation chart. I have 119 here.
And how many pages is that?
This is a 4-page exhibit.
And generally describe what it contains.
These are encrypted signal messages between Bill Null and another militia leader, Ian Partington from the Genesee County Volunteer Militia.
Okay, and in what platform is it this being used? What's being used to communicate? What platform?
Signal.
Okay, and is that a encrypted application?
Yes.
Okay, and what's the general content of the discussion again? I'm sorry.
There's discussion about training, and Ian Partington is asking about Adam Fox and asking Bill Null for a recommendation, and Bill Null tells Ian Partington that he supports Adam Fox.
Move for admission of proposed exhibit 119, please.
Mr. Seiler.
Stand on the objections.
Mr. Brown?
No objection.
We will be in.
Let's work through these. What are we seeing generally here, Agent Ippola?
So the green bubble is Bill Knoll, and then the blue bubble here is Ian Partington. And so the conversation thread goes left to right and then top to bottom.
Okay, can we start off, please, in the upper left, Adam? Can you read who's this message from?
It's from Bill Knoll on August 10th, 2020.
And it's again going to Mr. Partington.
Yes, sir.
Okay, can you read the message of Mr. Bill Knoll into the record, please?
Sure. Yup, I'm not doing many protests. They don't do shit. Most of my guys are focusing on training. Others still just want their pictures in the paper.
Before we move on, Mr. Phil Robinson, remind us who he is.
He's the other leader of the Michigan Liberty Militia, who's frequently in the newspaper.
Okay, and is that the gentleman that I think you indicated last week was referred to as the Peacock?
Yes.
Okay. Can you move to the next bubble, please, Adam? Does Mr. Partington have a response to Mr. Knoll's statement?
Yes, he states the media.
Okay, and moving on, please. The next message, who is it from?
From Bill Knoll?
And can you read that into the record, please?
Sure. Bill Knoll states, Sunday, like noon to 3, I'll look into it more, but going gray man to see who will actually show up from the community.
Okay. And the community being referenced there, what is that?
So he's talking about showing up at protests and then not wearing his kit and blending into the crowd to see if he can see who's actually supporting the militia.
Okay. Next, please.
Ian Partington stated, yep, all that does is piss us off because they lie about the pictures.
Moving on, please, Adam. Does Mr. Partington make another message, send another message after the last one you just read to Mr. Bill Knoll?
Yes, same day, August 10th, 2020, Ian Partington stated, I would gray man too. No need in giving those POS another tag to find you with.
What does POS stand for?
Piece of shit.
And what does gray man mean?
So that is dressing down as a civilian in nondescript clothing and blending in with the crowd as opposed to going full battle rattle.
Okay. Next message, please. Does Mr. Bill Knoll respond to the last message by Mr. Partington?
Yes.
What does he say?
All right. He stated, yeah, when I start fucking these fucktards up, I don't need the whole group taking the hit.
What group is being referred to there?
Michigan Liberty Militia.
And that's Mr. Bill, it's where Mr. Bill Knoll's the leader, is that correct?
That's correct.
Okay, moving to page 2, please. And can you read who's this message from?
From Ian Partington,
And who's it to?
Bill Knoll.
And what does it say?
This is now jumping up to August 13th. It says, hey, was your group going to Adams trainings near Cadillac?
And does Mr. Bill Knoll respond to that?
Yes.
What does he say?
Not sure yet.
And the next message in the string, who's it from?
From Ian Partington.
And to Mr. Bill Knoll?
Yes.
And what does the message say?
It says, okay, I'm asking because it sounds good. And if you guys were going, maybe give the rest of the groups an education on how good bad it is. I know Adam is a decent dude, very driven. My concern is he is a new CO and that's a tough job for anyone.
The letter CO, what does that stand for?
He's commanding officer.
Okay. Does Mr. Bill Knoll respond to this message?
He does.
Is that what we're looking at now?
Yes.
What does it say?
Says, I've done training with them already. They seem to have their shit together.
Okay. Does Mr., the next message, who's it from?
From Ian Partington.
And who's it to?
Bill Null.
And can you read that into the record, please?
Yes. Ian Partington asked, Wisconsin? For sure. I think you mentioned it before. Just looking for an info bridge to get others interested in doing the same.
And does Mr. Bill Null have a response to that?
He does.
Okay, and is that what we're looking at now?
Yes.
Can you read that into the record, please?
Sure. Bill Null stated, I hear you, man. I've been talking and working with several groups across the country. I think Adam will do fine. He's got good people with him.
And does Mr. Partington respond to that?
He does.
Okay. Can you read that message into the record, please?
Sure. This is still, again, from August 13th, 2020. Ian Partington stated, I hope so. As I understand, he has a few felonies. Maybe I have that wrong. If he does, and he gets set up, we're all going to get smoked.
Moving to page 3, please. Does Mr. Bill Null respond after that message by Mr. Partington?
He does.
And can you read that into the record, please?
He says, I don't know anything about that. I'll ask him about it the next time I see him. We're all going to have to make hard choices soon with the way shit's going.
And that was on, Mr. Bill Null says that on August 13th of 2020. Is that correct?
Yes, sir.
And that's before the daytime surveillance on the governor's cabin on Birch Lake
Yes.
and before the Luther FTX and the nighttime surveillance on September 12th. Is that correct?
Yes.
Okay. What are we looking at here, Agent Empla?
This is a message from Ian Partington to Bill Null, same day, August 13th, 2020.
Can you read that into the record, please?
Sure. Ian Partington states, agreed. If he is on a list, it's best we friend him, but not train with him. That way, feds can't make us all sticky to a boxcar move.
Sticky to a boxcar move. What does that mean?
It's a reference to getting evidence against the whole group together.
Okay. Does Mr. Bill Null respond to that?
He does.
Is that what we're looking at here?
Yes.
Can you read that into the record, please?
Bill Null states, yup, having felons in a group or thin blue liners will probably make the same results.
Thin blue liners, what is that a reference to?
It's not a reference to people who support law enforcement.
Okay. Mr. Partington, respond to that message by Mr. Null.
He does.
And is that what we're looking at here?
Yes.
And we're still on the 13th of August, is that correct?
Yes, sir.
Can you read that into the record, please?
Ian Partington stated, the problem is cops they have POS in their ranks, just like we have felonies POS in our cause, trying to do shit they shouldn't, authority issues, etc.
Does Mr. Partington continue with another message that we're looking at right now?
Yes.
Okay, can you read that into the record, please?
Ian Partington stated, unless the felon blue line has a wake-up call and is getting his shit together, then there's hope for that.
And moving on to the next message sent, is it who's it from?
From Ian Partington,
And what does he say?
he says, most of my LE buddies are retired and don't like the shit going on like we have been seeing.
What does LE refer to?
It's law enforcement.
Okay. And does Mr. Bill Null have a response to those messages by Mr. Partington?
He does.
Is that what we're looking at here?
Yes.
And again, we're for the record on page 2, bottom of the page. Can you read that into the record, please?
Sure. This is August 13th, 2020. Bill Null stated, well, I trust more people with felonies to have my back. Blue liners will always have the blue lines back, not mine.
Moving to page 4, please. What are we looking at here?
Another statement from Bill Null to Ian Partington.
And this follows the last statement you just read into the record, correct?
Yes,
And same day, about 20 minutes later, is that correct?
yes, sir.
And what does Mr. Bill Null, what does he say to Mr. Partington in this text message?
He says, well, let me be more clearer, I guess. I don't trust most people in general. Criminals are POS, just the same as cops. I've been fucked over in business, never by a person that has a record. They've never been caught, is all that means. I know several people that have been fucked over by cops.
And does Mr. Partington make a response to that?
He does.
Can you read that into the record, please?
Ian Partington stated, my take on what you're saying is that felony became a cop. So he could be a felony and get away with shit.
Does Mr. Bill Null have a response to that?
He does.
Is that what we're looking at here?
Yes, sir.
Okay, go ahead and read that.
Bill Null stated, that's one way to put it. Not all cops are bad, but they will always have cops' backs, not ours in the end. Regular people that are punished for crimes and given felonies have done way less crime than most cops.
Does Mr. Partington have a response to that observation or opinion of Mr. Bill Null?
Yes,
Is that what we're looking at here?
yes.
Can you read that into the record, please?
Partington stated, they were people before they were cops. They learned about being shitty before the badge. They were either ignorant of what real right and wrong is, or they choose to be for the group brotherhood they are a part of. Just like you said, you trust a felony over a cop, that's the same.
Does Mr. Bill Null make a response to that statement?
He does.
Okay, and is that what we're looking at now?
Yes.
What does he say?
He says, well, no, because a cop is above the law, a person with a felony is below the law. Cops are terrorists, plain and simple.
And that was on when Mr. Bill Null said the cops are terrorists. That again is on August 13th. Is that correct?
Correct.
Okay. Does Mr. Partington have a response to that?
He does.
Can you read, is that what we're looking at here?
Yes.
Can you read that into the record, please?
Ian Partington stated, they were a terrorist or a felony mentality, their weak moral compass before they became a cop. Shitty humans if they don't change their ways. Their brotherhood is the problem as it's lost its way. Now they are reaping the benefit of the current social situation. On top of the communist movement working to keep LE looking bad. Not saying cops don't do bad shit and it's all a commie thing. The root problem is shitty people who don't want to change their ways, using their position to hide what they do in combination with other cops trying to raise a family or chase their goals to head turning. I'm not arguing this, I'm sharing my thoughts with you. So I hope this isn't causing tension between us discussing this.
Okay. And the last message there again is on August 13th. Is that correct?
Yes, sir.
Okay. Thank you. Moving to proposed exhibit number 20. Keith, are you familiar with that?
Yes.
120, if I misspoke, I'm sorry. And what is proposed exhibit 120?
This is a screen capture of a wired chat group from August 10th, 2020. It's the FAFO chat group, so the fuck around and find out group, which is the operators of the terrorist attack.
And of the defendants, which of them are part of this chat?
Eric Mauder.
Okay. How was it obtained?
This was obtained via logging in to CHS Dan's wire handle and then capturing the screen captures before they were deleted.
Is this part of the day-to-day thing one of the day-to-day things that you were doing to capture the evidence that we're presenting today?
Yes, me and my team did this daily.
Okay. What's the general content of this chat?
This is Adam Fox telling the operators how they will survive and how they'll refine their plan moving forward so they can live.
Move for admission of proposed exhibit 120, please.
Mr. Sykes.
It's stand on our objection.
Mr. Whitmer.
Short one. You said there are all fours in this chat group.
Yes, sir.
His name doesn't appear on the exhibit.
That's correct.
He's softly,
Yes.
I mean, on this one in particular, you said before you weren't sure.
By this time, they were set to a 24-hour timer to self-delete.
Okay. Don't tell me you didn't see it in 24 hours. They wouldn't see it.
Correct.
Thank you. No objection.
You will be admitted.
I'm sorry. To clarify, it's within 24 hours after that person opens their phone and opens the message. So if you didn't open the message, it would still be on your phone. Once you open it, it's the 24-hour clock starts then.
I can say more questions. Okay. There's a truncated exhibit again, doesn't show it before or after. Could you explain where this one page fits into the entire message going back and forth?
Sure.
How many more pages were with this thread?
So this particular thread had, I would say, probably around 100 pages. But what happened on this thread is the FAFO group, Adam Fox had invited the operators into the FAFO group on Wire. And then what he did is he took them and transferred the FAFO group over to Threema. And then operators were then on Threema, a different platform with the same chat group.
So there's 100 pages go on this one page.
There's 100 pages total I'm guessing on that. There's 100 or hundreds of pages in the Wire chat group, which is the total before and after. This is kind of right in the middle of August. So this particular exhibit is right in the middle of their discussions on the FAFO group. And then there's another chat group in Threema, which probably has another 50 to 100. These are just really rough guesses of chats during the duration of the Threema chat, which is the extension of this Wire chat.
But you continue to use the word they, describing these exhibits. My client's name, not on this exhibit.
Your client is not on this particular exhibit, but he's in the chat group and he does regularly contribute to the chat.
I'm just asking.
Judge, these are questions that are ripe for cross-examination. They don't go to the foundation of the proposed exhibit. I mean, he's trying to get his cross in early, and I understand that, but I'd ask the court to limit him to, voir dire means, is this what it purports to be?
I think the last question to Mr. Barnett, I think was going to be that Mr. Mauer, his name is not here on this page. Is that correct?
He's been asked and answered, but yes.
Okay. Do you have any other questions?
I do.
Okay. You still have no objection to the submission of the document?
I have no objection.
That does not change the court's position of this previously.
Thank you, Judge. And Mr. Impla, just to be clear, I mean, this was all turned over in discovery to all counsel, is that correct?
Yes, sir.
I mean, not just this page, but,
Your Honor, the relevance of this.
well, because
You
he,
talked about discovery.
yeah.
We've already had this discussion relative to discovery. Pages have been turned over. I think the jury understands that there were additional pages. This one has been selected as it has with other ones. To the extent necessary, the objection is sustained. Let's move on.
Thank you, Judge. All right, let's get into this again as exhibit number 120. Can you tell us what we're looking at here?
So this is a screen capture of the Wire chat group, the FAFO chat group. And let's start here. This is Red Hot, which is the alias for Caleb Franks. Deansy is the Wire handler alias for Adam Fox.
Who is Beaker?
Beaker here, this is Dan Harris.
Okay. And what is, if you would, tell us what the box content is and how the box got there.
Sure, so I put the box here. provide context to the pertinent portion of the exhibit.
Okay. Why don't you read the exhibit from top to bottom, please?
Starting with Caleb Franks or starting with the box?
Starting with, Caleb Franks, Red Hot.
Okay. Even if we plan, it's highly likely we are either isolated due to being identified or just taken out in the mission isn't close. I don't want anyone to downplay the camera footprint that is everywhere. Even if we covered our faces, we will be found in a day or two. Adam Fox replied, well, this is why we organize the puzzle. Put it together, tear it apart, out, back, together, tear it apart again, and we do this until we can't tear it apart anymore. Dan Harris stated, train like they did in Den of Thieves. Adam Fox said, our survival depends on our ability to fight together as a cohesive unit. Say what you want, but when we're done, we will be ready. We have some amazing leadership and training, guys. Get focused and stay focused. We aren't running a suicide mission. Caleb Franks stated, finding the routes without cameras and cover would be the most important, or cutting power to shit. Adam Fox stated, we're going into this to bring everyone back home. See problems, simply require solutions. You could also alter facial features as well. Change eye color with contacts. Our job now is to put puzzles together and tear them apart until we can't tear one apart.
Okay. I'd like to draw your attention now to proposed exhibit 124. Are you familiar with that?
Yes,
What is that?
this is Facebook chat group from the Leaders Coalition chat. It's a private chat amongst Michigan leaders, which was put together by Adam Fox for planning and cover of the Luther FTX.
How was it obtained?
This particular one was obtained through logging in through Dan's Facebook account, but I have the same chat as well from Facebook search warrants.
Just for the record, Dan, who?
This is CHS Dan.
Thank you.
And can you give us this is a,
This is a long one.
yep.
This is a 9-pager.
Okay. We talk about the Leaders Coalition. Leaders of what?
These are leaders of militia groups around the state.
Okay. And can you tell us generally what's contained through the 9 pages here?
Well, it's an invite. It includes an invite to the Luther FTX, and then it includes participation by Mike Null and Bill Null, and discussion of ideology and the war that they'll be fighting and the need to do this for their children moving forward.
Move for admission. Proposed exhibit 124, please.
If we expand on our projections.
Mr. Barnett?
Maybe a no turn.
Okay, let's go back on the record. Mr. Ralston.
Thank you, Judge. Move for,
Mr. Barnett, I think I answered. Do you have any objection to the addition of the
Just had a couple of questions.
Okay. While you're going.
Yes, sir.
Okay.
Is this, you said this is a leadership chat?
Yes, sir.
There's how many names are on this leadership check that were in charge?
Give me a sec, I'll count them.
Give me my counting ones, and how many are there and how many have not been charged?
Okay, give me a
Yeah,
sec.
objection as to the follow-up question.
I think, in case that this is not relevant for a number of other individuals.
Well, the relevancy relative to the exhibits has been discussed by the court previously. I understand the point, and then we go to weight, so it can be addressed in cross-examination, but the court doesn't believe it goes to admissibility with that.
But I just bring one up here. Ian Cardington, he was on a previous exhibit as well, saying quite a bit. Is he listed on this as well?
Yes, sir.
And when's he charged?
Objection, relevance. Thank you, Judge. Can we have page 1, please? What are we seeing here, Agent Impel?
So these are the members of the Facebook chat, and then I put the boxes around individuals who are part of our subjects of investigation chart.
Okay. Eric Molitor's not listed on there, is that correct?
That is correct.
This is set up by Adam Fox, is that correct?
Yes,
Okay. Who's the leader of the group that Mr. Molitor is in?
Adam Fox.
Okay. Can you move to page 2, please? Or
Back to that, right? Association, militia, nothing. Basically on the Facebook page. So we look at those, all we had is hearsay comments from Adam Fox, who's filed here today, on Fox, and Fox is the only one that's talked about there. We also cross-examined, I just think that's false evidence. Putting Mr. Molitor in false category here.
the evidence admitted last week was very pointed towards Eric Molitor joining Adam Fox's group and Adam Fox being the leader of that group.
But if the court's recollection is correct, the testimony was that Mr. Molitor was a follower on the page of Mr. Fox. If you turn the characterization, each party is free to do that as they wish. So, go ahead.
Thank you, Judge. Actually, Adam, can you go back to the first page, please? Thank you. And down into the body of the messaging. How does it start off, Agent Impla, with the first post there? Can you read and just read those into the record if you would?
Sure. So this is August 27th, 2020. Adam Fox stated, I put leaders from as many militia as I can think of in here.
And just so that we are all on the same timeline, is this before or after the daytime surveillance?
This is 2 days before the daytime surveillance.
Understood. Continue, please.
Adam Fox stated, our time is coming. Time to put aside petty differences and get united and ready to mount up together.
Continue.
Adam Fox stated, we should really have open lines of communication between all of us in Michigan anyway. So let's start here and develop into a more solid method.
Going to page 2.
Adam Fox named the group Leaders Coalition Michigan.
Okay. And the following day, what's the messaging?
Adam Fox stated, that's why I'm trying to get a head count, LOL.
Continue.
We will have more than enough space for everyone. Just a matter of planning accordingly so we can make the weekend most beneficial.
Okay. This is the 28th of August, correct?
Correct.
And do you know what weekend is being referred to there?
This is the planning for the second weekend of September, the Luther FDX that is being set up.
Okay. Go ahead.
Ian Partington asked, what day again? Ian Partington asked, in general part of the state?
Continue.
Adam Fox stated September 12th and 13th, 30 minutes south of Cadillac.
Continue.
Adam Fox stated, think we rallying at Walmart and Cadillac so people don't get lost. Also, cars won't be able to make it back to the property.
What property is being referred to there?
The Wolverine Watchman remote hunting property in Luther.
Okay, continue, please.
Can camp or make hotel arrangements.
Moving to page 2.
Ian Partington asked, what's on the agenda in respect to OPSEC?
Does Adam Fox reply?
Yes, Adam Fox stated there's an itinerary set. Will be live fire CQC, medical, dry fire drills, whole lot packed into a weekend.
CQC, what does that stand for?
Close quarter combat.
Moving to August 31 at 2020. Does the chat continue?
It does, and just to be clear, this is like a 300-page chat, and I've only selected pertinent ones for that day. It's not flowing directly into them. Each day is like a new header, and then I put in the pertinent chats.
Understood.
Fox said, I'll try still shoot him in the head with it, though.
Okay, what is that a reference to?
In reference to getting beanbag rounds and shooting at spectators or law enforcement during rallies.
Okay. And is there any response directly to that statement by Mr. Fox?
Yes, Mike Knoll gives a thumbs up emoji.
Okay, moving to the bottom of the page there, what's the next date?
September 3rd, 2020.
Okay, and does Mr. Fox send a message out?
Yes, he brings out September 12th and 13th, 30 minutes south of Cadillac.
And continue, please.
Fox stated rest of details will be given the night of the 11th as far as the meetup point.
Okay. Is that an example of operational security?
Yes.
Continuing to the 5th of September on this Michigan Leaders Coalition chat. What's the next message we see?
Ian Partington again here. Is that where you want me to start?
Yes, please.
Okay. So September 5th, 2020, Ian Partington states, total anarchy makes us individually vulnerable to ourselves and complete control crushes any reason to live. There has to be a cultural balance.
Does he go on?
Yes, he said, as militia, my thought is to let the feds handle these rioters. My guess, if we walk in the will round us, all us, and then put us all in the same short-staffed prison yard.
Okay, the next author there, Ragnar Bill Null, is that Mr. William Null?
Yes, this is Bill Null. Ragnar is an alias or handle.
Okay, and can you read that, please?
From where I'm standing, if you're not ready for the fight, you're doomed. We are at war against half the sheep in this country and the rest of the world. If you back the blue, you're a fool. They are just as much the enemy of freedom as the feds and BLM/Antifa.
Does Mr. Partington have a response to that?
Yes, he stated, thus the problem of a job versus a cause.
Does Mr. Bill Null respond to that?
He does.
Go ahead.
He said, it's mindset as well, brother. We've all got jobs and lives, but if you're not willing to fight for it against all enemies, our kids will be in worse shape than we are.
Correct me if I'm wrong, but I think we heard Mr. Croft referencing his kids as a motive to fight last week. Is that correct?
Yes.
Okay, continue, please.
Ian Partington stated, thing is, a Fed agent thinks the same.
And does Mr. Bill Null have a response to that?
He said, yeah, I know, but they run the plantation. We're on slaves on it. You want freedom, you have to take risks. I don't know if we need to stand against the sheep or not, but if we just stand by and watch, we will lose either way.
Moving on to the 9th of September of 2020, and this is again before the national FTX at Luther, correct?
Correct.
Can you tell us what the next message is?
Objection, I was just curious, Your Honor, if we have a timeline, and this is chopped up or truncated as well from the other messages, or is this the continuous stream?
If I understood the testimony from the agent, communicated that this was from hundreds of pages, and that he created a date header and selected this. Is that correct?
Yes, Your Honor.
Mr. Barnett, and John.
I'm sorry,
So this one is from September 9th, 2020.
And who's the message from?
Adam Fox.
Can you kind of walk us through the rest of this page, please, or down to the 19th?
Sure. She's gonna spend $1 million to upgrade her residence because she's a tyrant bitch.
And the next message?
Ian Partington stated 8-foot fence electrifying. Adam Fox stated laughing my fucking ass off.
And does Mr. Fox message out?
I said that, Jack. He didn't say that. He said LMFAO. He didn't say those words. Let's testify to what he said. Let's testify to what he said on there, not dicta. Thank you.
Okay. Agent, I understand there may be common acronyms and texting and stuff like that, but if you could, if it's letters, it would be appropriate to simply do the letters, so it would be sustained as far as that. Okay. Go right ahead, Mr. Walton.
Thank you. And just obviously it says LMFAO, correct?
Yes.
Okay. And go on and continue with the box content there.
So this is September 9th, 2020. Adam Fox asks, who wants to get her? Followed by you down.
Okay, the content that we see from the 9th of September, are you familiar with any security measures being taken at the governor's residence in Lansing around this time?
Yes, I am.
Tell us about that.
There was news articles which were publicly known and discussed by the group about a fence being put up around the governor's Lansing address. So this is the ceremonial governor's mansion in Lansing where the governor lived.
Okay. And moving on to the 19th of September there, the bottom of this page, you see that?
Yes.
Remind the jury who George Bunyan II is.
So George Bunyan is an alias for Joe Morrison. This is Exhibit 1, subject to investigation. He's the lower left here, the founder of the Wolverine Watchman.
And again, just this is a Facebook chat group of Michigan militia leaders that Adam Fox included in this. Is that correct?
Yes.
Okay. And what is, and starting with the George Bunyan author, can you read that into the record and walk us through what follows on the next page, the next date header, please?
Sure. So this is from September 19, 2020. Joe Morrison stated, the storm will be here shortly. Adam Fox replied and said, yup, that's why we've been training and preparing like we have. Adam Fox stated, another FTX in Wisconsin coming up too.
Let me stop you here for a minute. Is he referring to the Cambria, Wisconsin FTX that we heard about last week? Okay, sure. You told us last week there was a FTX in Cambria, Wisconsin. Is that correct?
That's correct.
And Mr. William Knoll and Michael Knoll attended that, right?
That's correct.
And they trained with Adam Fox there?
Leading questions, we asked for a question that the witness can respond to, not feeding them the information and letting them respond.
Introductory questions, trying to move to the question that was objected to, Judge.
I think the first one in referencing the location is perfectly appropriate, but there were leading questions that's what we'll be saying.
Okay. Remind the jury which defendants here in the room participated in that July FTX in Cambria, Wisconsin.
That was Mike Knoll and Bill Knoll.
Okay, and remind the jury of who else was there in terms of, was Adam Fox there?
Yes.
Okay.
But once again, we have leading questions left and right. Ask a question, we'll get the answer from the witness, not giving the witness the answer. Please.
I disagree. Those were not leading questions, Judge.
The last one when you asked what Adam Fox there, it's not any questions. The two previous ones, I think the first one may have been introductory, but the one after that, so if you could just make sure that you're phrasing the questions appropriately.
Certainly, Judge. So again, going back to Cambria, remind us who was there.
So Cambria had Mike Null, Bill Null, Adam Fox, Barry Croft, Undercover Mark was there, Dan was there, as well as the Wolverine Washington team.
Okay. And what was the date of that FTX?
That was July 11th and 12th, 2020.
And the reference here about another FTX in Wisconsin, that statement by Mr. Fox is made September 19th of 2020, correct?
Yes, it's a reference to the October 24th planned FTX in Wisconsin, which would be a cover for the group to buy explosives from Undercover Red in preparation for the next.
Judge, wait a minute, I'm a little confused here now. Are we having two FTXs in Wisconsin? Which state are we talking about?
I think the witness was pretty clear.
I'm pretty confused.
Let me do this. Ladies and gentlemen, it's a good time to take a little break. We'll see the jury. Okay. Ladies and gentlemen, if you could make those selections while you're in there on the break. The menus are here. Okay, the record can reflect the jury that a program everyone may see. I think I understand the answer to be here on that one as well, but I think what we'll do is I'll overrule it in that sense, like Mr. Wilson, perhaps breaking the questions and answers up into shorter sections and segments, maybe more appropriate.
No problem.
So that way everyone tuned to the jury can follow it.
Will do.
Okay. Mr. Nussio, anything else you want to do? Mr. Sykes?
No.
Mr. Barnett?
Just a second, Mr. Sykes.
Sure.
Well, I just recall that our testimony is not excessive. He indicated, I think, Friday that Wisconsin's brought up. Second day, he didn't know whether he was still there or not, so we get the benefit, they developed, they weren't. Now they're there both days. I'm concerned about the question of what's going on here. And it's well beyond the exhibit, obviously, but I think there's just a misrepresentation going on here, and it's not my client, but currently I'm in the position of saying something.
Mr. Nando and Mr. Cyber, I assume you would agree with that position you don't.
It tends to be a little bit confusing. I understand what the Attorney General's office is doing. But the original question is, the other FTXs in Wisconsin, when that comes about. The scheduled date of that, I get it, but to now speculate as to what's going to occur at the October 24th FTX is somewhat misleading, unless there's additional foundation regarding that FTX. Because the question was, when is that FTX supposed to take place in Wisconsin? The witness has answered the question. But what happened is the witness has declined back into these are cover-ups because of the explosives. And I think it tends to be a little bit misleading. But I think the court is very asking for all to cut it out so that it's not so confusing.
Mr. Cyber, anything else?
Just briefly, the speculation is who is going to be at the 24th versus identifying that my client and his brother were not at the, they weren't there for conversations at the first FTX in Wisconsin. I believe there's confusion and that the jury is going to be very confused on who was there and who wasn't, because now the witness is testifying, these are people that are supposed to be there, but we don't know that they are yet because we haven't gotten to that FTX. And that's why I raised the initial objection. There's 2 FTXs now. Which one are we talking about? The first or the second? The one that you identified that you didn't know that my guys were there or not in conversations, or now you're saying these are the people that were there. So that was the objection.
And the way that I took the testimony conclusion last week was that Cambria one, forgive me for saving me, was that the agent testified that he could not prove that either of the brothers was there. That's my recollection. The way that I took the testimony relative to the other FTX was the list of people who were thought to going to be attending. Obviously, somebody does or does not. That doesn't mean just because they were on the list or got an invitation or something along those lines. But I think that any confusion relative to that will be addressed with the breaking up, so to speak, of the questions. And Mr. Wilson, Agent will perhaps to, much like we did yesterday, or excuse me, on Friday and Thursday with exhibits when a chat group was mentioned, the agent testified whether or not any of the named defendants were in that chat group. Perhaps attendance of these 3 versus other individuals may be an important distinction that the parties can provide. So, any issue with that, Mr. Wilson?
Not at all. The attendance, you said the attendance of these individuals.
I'm sorry, to give an example like we did yesterday. So if an XTX or FTX is going to be discussed, for example, so when Cambria was discussed, the fact that the Null brothers, he testified that he couldn't prove that they were there when that speech was given on a particular morning, just to identify which of these 3 defendants may or may not have been there in their space.
Certainly.
Does that make sense?
Yes.
Any issue with any of that?
No, sir.
Okay, Mr. Mullins, you have anything else for you?
We would concur with court's request, Your Honor, nothing else.
Okay, Mr. Sarge.
Nothing else.
Mr. Barnett.
Just to help remind everyone, no one's apparently wants camping to be repeated at some point. That's what the issue was in context. Prior to that.
That's my understanding of the text message. And I understand too that this situation is a little unusual because the direct of this witness has gone on for a while and will go on for a while. But certainly all of these things can be addressed through cross-examination. I would assume that they will be. But obviously the attorneys on the other side will have the chance to be able to comment on these things. But with that, let's take a 10-minute break. We may show a little bit of noon this morning, but let's take a 10-minute break to give everyone a chance to take a
We'll go on the video.
Yeah, sure.
Oh, got it. Yeah.
Okay, so we have everybody back before bringing the jury back in. Anything else we need to discuss? Mr. Wilson, let's start with you.
How long do you want me to go to, Judge?
We'll go until afternoon. Why don't you just keep going and then based on schedule.
Okay.
You don't do anything?
No.
Mr. Sever?
No.
Mr. Barnett? No, Your Honor. Okay, all rise for the jury. All right, everyone.
Thank you, Judge. Agent Imply, I think we were on page
6, thank you.
of Exhibit 124 there, the Leaders Coalition Michigan chat. And if you would continue, please, with where we left off. I think it's, so what's everyone going to do?
Sure. So this is September 20th, 2020. Adam Fox stated, so what's everyone going to do if the left tries to burn down the country if Trump wins, or what are we going to do if they elect a pedo like Biden?
Continue on, please.
Adam Fox stated, I think either way we're Fox.
And the box content here, what are we seeing there? Tell us who Francis Marion is.
So Francis Marion is alias for James Barney, who's a member of the Michigan Civil Defense Force. He stated, right now with rule of law, it's law enforcement's problem. Start fucking around and you're going to find yourself incarcerated.
Okay. Moving on to September 20th. Go back to that last message just a minute. Start effing around, and I'm using an acronym, and you're going to find yourself incarcerated, correct?
Correct.
Okay. I mean, is that what type of warning is that?
Objection, speculation. We concur, Your Honor. The document speaks for itself.
Mr. Barnett?
Can't add anything to those objections.
I think given his depth of knowledge in the case, it might be enlightening to the jury to understand kind of the import of that message.
I'll sustain the objection to the message.
Okay. The going to September 20th now. Continue on, if you will.
James Barney stated, if the Constitution is thrown out the window, then maybe it's time for guerrilla warfare.
So Mr. Fox have a response to that?
Adam Fox stated, well, let's be honest, it kind of is already.
Continue on.
James Barney stated, no,
And continue on.
we're a long ways from that.
Going to the next page, please.
Adam Fox stated, essentially every right we have is being infringed upon. James Barney stated, disagree. Adam Fox asked, how not? Francis Marion or James Barney said, can you drive down the road? Do you need a pass to go to work?
Okay. Moving on to the next header there, September 20th. Can you read those messages into the record, please?
Adam Fox stated, they already labeled us domestic terrorists April 30th.
What happened on April 30th?
That was the American Patriot rally at the Capitol in Lansing. So number 2 on Exhibit 2 from the significant events timeline.
Okay. Continue on, please.
James Barney stated, you know what I meant.
And and continue on.
Adam Fox asked, I mean, who's the real terrorist? Adam Fox said, being labeled a terrorist by a terrorist organization.
And for the record, that's EHHH, correct?
Yes.
Okay, moving to the next page.
Adam Fox stated, doesn't hold much ground.
Okay. And moving now to the 28th of September, and this again is the Michigan Leaders Coalition chat, right?
Correct.
Go on.
Adam Fox asked, checking in, how is everyone?
Okay. Does Mike Knoll acknowledge that in any way?
Yes, he provides a thumbs up emoji.
Okay. And moving to the 6th of October 2020.
Mr. Wilson?
Certainly shows that he's receiving and acknowledging the messaging.
Well, the jury can certainly get it. I wish it's too special.
we're on the 6th of October, is that right?
Yes, sir.
Okay, can you continue reading that content?
Adam Fox stated, our founding fathers would be called domestic terrorists today, with another emoji.
And go on, please.
Adam Fox stated, I mean, at what point do you just put it all on the line?
And continuing on, please, to the last page.
Adam Fox stated, this is from October 6, 2020, the ship's coming whether you are ready, prepared, or not.
Go on.
Adam Fox stated, there's people all over the country, guys, ready to go.
The next message.
Adam Fox stated, we just need to learn how to work together in this state, and we can really make a difference in restoring the constitutional republic here. Guy Garvin replied, revolution.
The message there, immediately above Mr. Fox's last message there, he talks about this state, correct?
Yes.
And is there any mention of Wisconsin in that message?
No.
Is there any mention of other militias in other states in that message?
No.
Okay. Thank you. You're familiar with proposed exhibit 125?
I am.
What is that?
This is a one-pager. It's from Facebook business records of Mike Null's Facebook account
Okay, and how are they obtained?
via Facebook search warrant.
Can you give us a general summary of what's in the messaging?
Mike Null provides a warning that civil war is coming.
Move for admission of 125, please.
No comment. That did stand on our objections and specific developments.
Mr. Barnett?
No objection.
125 was submitted, filtering the court's argument discussion.
Okay, let's, again, this is for Mr. Michael Null, is that right?
Yes.
And if you can zoom in, please, Adam, on the first box content.
We asked that through the whole completeness that we read all of it, not just the portions that they wish.
Well, so the rule of completeness would require that the other pages be incorporated into a separate exhibit being sought admission by a different party. Are you simply asking for them to read all of the text on this exhibit?
They're going to read all that are on this exhibit, yes.
Mr. Ralston, do you have any objection to doing that?
No, that's fine.
Mr. Nunn, do you have any objection to that? Mr. Barnett?
We support that.
Go right ahead.
Okay, let's start from the top, page number. We see, well, tell us what we see.
All right. So from the top, up here in August 26, 2020, there is a link that is shared. The link is titled, Shocking Footage Shows the Moment a Black Lives Matter protester is shot in the head, imposed by an armed citizens defending a car dealership. Violent unrest has been raging in Kenosha. Then there's another link under it. It's at the URL. There's comments. So these comments, oh, there it is. Wayne Hodges.
No, please read the whole title of the next one up there as well.
You want me to read a link?
No, we're not going to do that, Chuck.
Well, that's not a text that would have appeared in terms of the conversation. That's not a post that somebody would have made. It's simply a link. So I'm not going to require anyone to read that. What was requested is that they read all of the statements contained in it. So any statement, go ahead.
Judge. He read the link, but then he didn't read the title of the link underneath it. That's what I'm asking.
So he read the summary, which is the headline. He didn't read the URL, which is the link that he did.
Thank you.
Okay, go ahead, Mr. Ross.
Thank you, Judge. Continue on with the content above the box.
Sure. So Wayne Hodges replied, people are fed up with the intimidation, rioting, and looting. It's just the beginning. Wayne Hodges tagged, this is the Facebook ID of Mike Knoll, and said, during battle, the enemy of my enemy is my friend. After the battle, they are either friend or foe, their choice. This is Mike Knoll. He replied to being tagged and stated, Civil War getting closer and closer every day. Wayne Hodges tagged Mike Knoll's account back and said, it's upon us, pick a side. Mike Knoll replied, I'm on the side that hates the rioters, lefties, and still knows the government is out to get us. Another Facebook user, B.A. Salzer, states, play stupid games, get stupid prizes. Time to ammo and weapon up. It's almost time to stand up to the angry mob. So this is another link that was then posted after this chat. It's not related to the first comments. This link says, this is from 8/20. So it's a different date. Move is part of a broad Facebook policy shift towards movements with links to violence, such as a baseless internet conspiracy QAnon. And then it's got a link to a Guardian article about QAnon. And then the title is Facebook restricts more than 10,000 QAnon and US militia groups. And then another user, Clint Clark, stated they are going down, but they definitely are attempting to cheat at this election. Stay vigilant, my friends.
Moving to the left side of the page, what do we see?
So these are shares. So this is under the shares tab of Facebook. These are shares after Bill Knoll's post. So,
Bill Knoll's post, or
excuse me, Michael Knoll's post.
the one where he says Civil War is getting closer and closer every day?
Okay, which post are we talking about that got shared?
So it's the first box exhibit here on this page on the right. So how these work?
Can you zoom back out to the full? It's just that I'm not ignoring you. I just want to make sure that they didn't.
Yes, sir.
So can you show me the original comment or link or whatever that got the shares that are on the right side?
There is no original comment or link. These are just, all these shares and comments are just unrelated, but they're, the way Facebook provides it, instead of chronologically going down, it goes chronologically going up. So the sequencing here is from the bottom of the page to the top.
And so is the right side related to the left side at all?
No.
Okay. I certainly take part of what Mr. Sider was saying. So with that knowledge that the agent just imparted on us, let's begin chronologically and go that way. And obviously, then if there's additional objections, maybe go. Okay.
Thank you.
On the left, or on the right side rather, Agent Employ, what do we see from the bottom up?
So from the bottom up, 8/27, there's a post, and it's the user of this account. Mike Knoll was tagged by others. Preston Perez mentioned him in a comment, and that content was owned by Preston Perez. So this is a tag by another user of Mike Knoll. And then these two things are unrelated. Mike Knoll replied to your comment on a post from August 26, 2020. I always have plates when I go to things like this, kind of like having my gun. Better to have it and not need it than to need it and not have it.
Continue.
So these are all independent, none of these relate to each other. Then Preston Perez tags Mike Knoll in a comment with different content owned by Preston Perez. And this is a separate comment now. Mike Knoll replied to your comment on a post from August 26, 2020. Always have to be ready.
Okay. Thank you.
Could the agent explain to sheriff, because there was an original post that gets shared, these are the comments under the post. So what was the post that was shared? If there wasn't the shocking footage shown of the armed citizen, what was it? What's the content?
So these two exhibits are unrelated, and I don't have any reference to Michael Knoll's comments here. I don't know what he's talking about.
There's windows at the top on the right, those are shares. Do you know what is being shared, or is that simply true?
Being shared here is an object ID, so it's a picture that can be found by searching the pictures that were delivered by Facebook, but I can't tell what it is.
Okay, thank you. Mr. Ralston.
Thank you, Judge. Let's turn to the end of August of 2020. And I want to direct your attention to the daytime surveillance. You remember you recall the daytime animation that we admitted last week, is that correct?
Yes, sir.
And that was, that surveillance, where was it based?
The daytime surveillance was based around Birch Lake and in Elk Rapids in Antrim County.
Okay, and when you learned about that surveillance being planned, did you take any steps?
I did.
Tell us about that.
I contacted the governor's protection detail and advised that anybody who was at the governor's cabin on Birch Lake should not be present on the 29th.
Okay, and how much in advance did you learn about this surveillance that was planned?
Approximately 2 days.
Okay, and of the defendants here, did any of them participate?
Yes.
Who?
Eric Molitor.
Okay, and tell us if you will, give us a timeline of the surveillance, and let's start with who drove.
Sure. CHS Dan drove in his personal truck.
And how did that come to be?
CHS Dan left and picked up Adam Fox. I told CHS Dan that he needed to drive to maintain control and maintain that no attacks actually happened that day.
Okay. Familiar with proposed exhibit 126?
I am.
What is that?
So this is a 4-pager. This is photographs of Adam Fox's phone, and these are encrypted wire messages between Adam Fox and Eric Molitor.
How were they obtained?
They were obtained via search warrant.
Okay. And when did this exchange occur between Mr. Fox and Mr. Molitor?
So this is the invite from Adam Fox to Molitor, and it started on August 27, 2020, went through the 28th. And then the final chat is on the 30th, so after the surveillance on the 29th.
Okay. And what is the general content of the communications between Mr. Molitor and Mr. Fox?
So these are one-on-one conversations in which Adam Fox invites Eric Molitor on a recon for a mission, and then following the recon and the coordination about which attack location they were going to be looking at, Adam Fox tells him not to tell anybody and to keep it a secret.
Move for admission of proposed exhibit 126, please.
Mr. Romney? Okay. Mr. Simon?
Please stand on the objection.
Mr. Parner?
Short and quiet. Do these include any of the invites to the other 4, 5, 6 individuals that were invited to this same?
Objection outside the scope of ordeer for admissibility.
Mr. Burnett, how is that related to the admissibility proposed to the 26?
It's out of context, Your Honor, to what really happened.
Okay, well, the agent testified that it was a one-on-one conversation between Mr. Fox and Mr. Mahler.
Other than the 5 others, at least invited, Your Honor, to be presenting this as a one-on-one conversation with one of the last stage, all part of the often late. Just finding proper context.
Okay, well, we'll have an opportunity to ask questions about any of the exhibits that are admitted on cross-examination. Any other lawyer questions?
No, Your Honor, no objection.
Okay, 126 will be looking.
Thank you, Judge. Why don't you walk us through this agent info, starting from the top?
Okay. I'm not actually sure what day these are. It's August 27th where it starts here. So this day, Adam Fox says, "My bad, bro, hold up. We will be going to a new app soon that costs like $2.99. Then on Thursday, August 27th, Adam Fox sent a message, "Want to go for a ride Saturday and do some recon." Barricade, which is Eric Molitor's handle, asks, "You got a place in mind? I'm dropping the kids off tomorrow to the X in Big Rapids. Already planned on scoping out hotels and motels for some stuff I heard about. Our Cadillac crew has us in surrounding areas under watch, so that's badass. We got a lot of good people in Michigan, dude. But anyways, where's this ride you want to take?" Alpha Fox, which is Adam Fox's wire handle, is stated, "We're doing recon on a high-profile vacation house." Followed by UN. Eric Molitor stated, "Load out. I need to know where to meet, time, bro." Adam Fox stated, "Copy that. We'll let you know. Price, scoop you on the way. Send me your address." Eric Molitor stated, "I've got another guy with me tomorrow who has stood side by side with me as well. 10274 S39 RD Cadillac MI."
Mr. Chairman, I don't believe addresses are supposed to be read in the record.
Well, we can't have both ways, but everything needs to be read in the record and certain things. I guess in the future, if there's any part of the exhibit that a party feels should not be read, let's deal with it at the time of commission. Let's go along, Mr. Wilson.
Thank you, Judge. Continue, agent info.
Adam Fox stated, "Okay, well, we may get pulled to Detroit, but Saturday will be just us with the boys. OPSEC reasons, cash for food, low profile, no trail of our existence there."
Going to page 2.
So Eric Molitor said, "Ha ha ha, tomorrow is Friday. I am a day off. He and I are chilling tomorrow. Yes, I am available." Adam Fox stated, "Okay." Then on August 28th, Friday, Adam Fox said, "What's up, bro?" Followed by, "Have 3 locations. Have intel on 3 already. We knocking out 1 and 2 tomorrow. 5-man team, all surveillance." Eric Molitor responded, "Understood, easy peasy." Followed by, "I won't be available for Lansing, but the other one I'm in." Adam Fox provided this screen capture of a route. This is from Grand Rapids up to Antrim County.
And can you just go back to that for 1 minute, please, Adam?
We asked the witness to describe where that red Google, whatever he calls it.
We're getting there.
Google tag, thank you.
Can you zoom in on that, please?
Mr. Burnett, you can remove an objection. It's not easy.
Thank you.
The red icon on the map sent by Mr. Fox, where does it end?
It looks to be, and it's fairly big and the icon on the map, and the map is small. Looks to me like it ends around the Birch Lake area.
Okay. And moving to the next page. What do we see there, Agent?
So this is a continuation of the last page, and the statement from Adam Fox was, that's our route. We starting in Lansing at 10 o'clock. So where in the route can you meet? And once I have that, we will figure out time. Eric Mulder responded, if I'm understanding this correctly, local number 1 is Lansing. Local number 2 is Bel Air. My road is light blue. I can meet up where it meets your path. Adam Fox stated, okay, find the exact location we can meet and let me know. Eric Mulder stated, looks like McDonald's in Calcasta would be a good meeting spot.
Moving to the next page.
Adam Fox said, this is more on our route, bro, and you can park in the church parking lot. Copy. Awesome. I'll get you time tomorrow when we leave Lansing. Eric Mulder stated, copy, busy man, driving and whatnot, but that will work just fine, brother. This is now, this is still the 28th there. Adam Fox replied, doing it Sunday now, brother. People couldn't get off work. Sunday will be 3 of us, so we pick you up if you good to go Sunday. Followed by, I'll just do the abbreviation, not the name, NVM. We okay for tomorrow, coming straight to you.
Are you aware of what NVM stands for?
Yes,
What?
never mind.
Go ahead.
Eric Mulder replied, LOL, so hard to organize as civilians. I wish this was a paid gig. Emoji. What time should I be ready? Or is that something to be determined tomorrow? Adam Fox stated he's going to be here around 10ish, so probably noonish for you. I'm coming up through Cadillac, so probably just snag you on the way. Eric Mulder replied, sounds good, man. Adam Fox said, copy that. Now on Saturday, August 29th, Adam Fox said, en route, 1 hour out from you. Followed by, I can't read this right here. So you want to patch in with us or what, brother?
Yeah. Check, unless we have a timeline on this second border stuff over on the right side. Thread continues, I don't know what date it's on, if it's Saturday, what time, there's no foundation right on the right side of the page. That's the agent, please provide that.
Agent, does the left side continue onto the right side?
Yes, it does.
So it's still Saturday, August 20th.
Yes, sir.
You're under that, it says barricade on the bottom of the left side. And if you go to the right side, it says it looks like shitty holster, I have works nice with it, that's all I can read. Excuse my language, but that's unknown, it's, I don't know why that would be the next statement, there's a gap here.
Okay, whether it happens.
No, when I was scrolling through the phone, or when my team was scrolling through the phone, tried to take a picture so they overlap, and the barricade right here corresponds with that statement, which Counselor is correct. It does say shitty holster have works nice with it. So this barricade corresponds with this, and this August 29th is continuous all the way down here to August 30th.
Okay, Mr. Barnett, does that answer your question?
It does not, I believe, my client said, excuse the language, shitty holster, I have works nice with it, I believe there's a gap here that's not being explained.
Okay, the agent has testified that it continues to the top by some of these gyms that are information.
Thank you.
Continue, Judge.
Yes, go ahead, Mr. Walton.
Agent Impel, starting with that box content.
Okay, so you want to patch in with us or what, brother? And Eric Molitor here stated, let me work with you for a little bit before I commit. I've had bad luck with groups. I'm always willing to work with people though. But I would like the ability to make an informed decision. Adam Fox stated, copy that. Let me know after that FTX. And I expect you keep everything from today between us.
Let me stop you here for a minute. What's the next scheduled FTX?
That's the Luther FTX.
Understood. Continue, please.
So now this is Sunday, August 30th. Adam Fox, this is Eric Molitor stated, copy. And I don't even know what you're talking about, brother. All good.
Okay. Thank you. Turning,
Just ask, I'm sorry if you can get your email or explain what's on the bottom of that page.
Can we read the lessons?
Sure. This is a message from Eric Molitor. I go to a lot of mill stores and run across a lot of deals on shit. What is you pistol? I will keep an eye out for a good. And just as you're reading this up here, I think Counselor is right. This is Adam Fox. So right here when it says barricade, this is Adam Fox asking Eric Molitor here if he wants to patch in. So there is a gap between here and here, but I reviewed it and it is from the 29th.
Thank you.
what role did you play, Agent Impla, on August 29th in terms of the daytime surveillance?
So I was in my car performing counter surveillance, so following behind the surveillance team. Then I was monitoring the live transmitter and I was in contact with the governor's protection detail to make sure there was nobody in the area.
Okay, are you familiar with proposed Exhibit 130?
I am.
What is that?
This is a timeline of the daytime surveillance.
Okay, and the dates and times accurate on it?
Yes, sir.
Okay, and I'm going to move for admission of proposed Exhibit 130, please.
Mr. Nunzi, goes to 130. Mr. Sager.
If you extend your objections, however, we'd like a lot of conversation.
Just one moment. Sure.
Agent, you mentioned Mr. Wilson, if I heard you correctly, that you live monitor for these events, is that correct?
Yes, sir.
On that, what do you use to create a timeline, or what did you use to create each of the number boxes in the first line?
Sure. So live monitoring was used to create some of them. Others, I used search warrant results from cell phones to determine the timestamp of when internet searches were performed by Eric Molitor. And then I also looked at the GPS data that was obtained from Dan's phone that was being transmitted.
Okay. On that basis, the court does believe that the proper foundation has been on record for that and follow
Thank you, Judge. And permission to publish copies to the jury, please.
Oh, yeah, paper copy?
Yes, sir.
Yeah. Okay.
Thank you. I think there's 18 in here.
Because we had
Hang on.
we have an issue with publishing as these events haven't been proven and aren't in evidence. Therefore, it's hard to have a demonstrative piece of evidence if the events have not been placed in evidence. It's actually against the rules evidence. Thank you.
But as the court just indicated, the agent indicated on what he based the entries on the timeline for, that was based on surveillance that he did, the live monitoring, GPS coordinates that were obtained after, among other things. In the court's mind, that's a proper basis. If Mr. Ralston chooses to discuss particular instances, that would simply be further documentation in support for those. But in the court's mind, sufficient basis has been done, as I indicated.
Thank you, Judge.
Can I hear one thing on the foundation? Page envelope, were White or Billy Mall involved in this daytime surveillance?
No, sir.
This wasn't much to do with yours, one.
Absolutely, Judge. Thank you, Judge. Let's turn to proposed exhibit 131, if we could. Are you familiar with that, Agent Empla?
I am.
Okay, and what is that?
This is a search warrant photograph of Eric Molitor's residence taken following the arrest on October 7th, 2020.
Okay, and that's at the address there on South 39 Road in Cadillac?
Yes, sir.
Okay, move for admission of 131, please.
Mr. Sauer.
Please stand on our objections.
Mr. Barnett.
No objection, Your Honor.
131.
Okay, what are we seeing here for the record? If you can just describe for the record, rather, Agent Employee, just generally what we're seeing in this picture?
Sure. This is an exterior photograph of Eric Molitor's residence and vehicle.
Okay. Are you familiar with proposed exhibit 133?
I am.
What is that?
Did you say 133 or 132?
133?
I am.
Can you tell us what that is?
Sure. This is the first audio clip that we have here of CHS Dan and Adam Fox and Eric Molitor in the car on surveillance.
Tell us how it was obtained.
It was obtained via live monitoring and review of the recording device that CHS Dan had with him during the surveillance.
Okay, in terms of the daytime surveillance, what time did Dan and Adam Fox arrive at Mr. Molitor's home?
Oh, so
It doesn't work.
right here on significant, the daytime surveillance timeline. So item number 1 is approximately 12:18 p.m.
Okay,
They arrived in Cadillac.
and how long did they stay there?
They stayed about 15 minutes till significant event number 2 from the daytime surveillance, which
Sure.
is 12:36 p.m.
When they left, who was in the vehicle?
It was Eric Molitor, CHS Dan, and Adam Fox.
Okay, and does Dan have a recording device?
He does.
And tell us, if you will, proposed exhibit 133, where does that conversation take place?
That takes place in the vehicle just after they got in and they're getting ready to leave, or on the road out to the main highway.
Okay, and does proposed exhibit 133 have an associated transcript to mark 133T?
It does.
And is that transcript accurate as to the audio that's in the proposed exhibit?
Yes.
Move for admission of proposing, or tell us generally what is the content of the audio that's in proposed exhibit 133.
So this is Adam Fox introducing CHS Dan to Eric Molitor, and then telling Eric Molitor that they'll be reconning the governor's house up in Antrim County.
Okay. Move for admission of 133, please, and 133T.
Mr. Mundey. Mr. Sauer.
Please stand on our objections.
And Mr. Barnett.
No objection.
Both will do.
Thank you.
going to read the application on the vote. Mike, go ahead, motherfucker. Little lesson, you know what I mean? Little lesson, tell you. I mean, you know what next year. Where that for? Get that you know, this is a vote, bitch. No, you can have those language, you didn't say you so you look at that somewhere else.
And you said we both had a head, that's what there was a stamps.
Yeah, Agent Employment, during the course of your investigation, did you learn whether or not Governor Whitmer had a boat at the property?
I did.
Okay, and did she?
Yes.
Okay. You familiar with proposed exhibit 134?
Yes.
What is this?
Yeah, before we proceed to that, I did have a time question about this.
It sounds like a cross-examination judge as opposed to foundational for voir dire.
Well, what would the question be?
Your Honor, this occurred after Mr. Molitor had already shown me how to have the device outside.
That doesn't go to the admissibility of that document. It's certainly
Thank you.
Wilson, go ahead.
Thank you, Judge. Proposed exhibit 134, I believe, is where we were.
Yes, sir.
And can you tell us what that is?
So this is a conversation in the car between CHS Dan, Adam Fox, and Eric Molitor. It's the next sequential clip, an audio clip that we've described, and it's on the way up after they get on the freeway and they're heading north.
Does it have an associated transcript, Mark 134T?
It does.
And is that transcript accurate as to the audio in the exhibit?
It does.
Move for admission on 134 and 134T, please.
Mr. Neville. Mr. Seiler.
Please stand on the Judge.
Mr. Varner.
Yeah, this was totally taken out of context. This was on the way back, I understand. After they did some things over there. This was not sequentially going up in the next thing they have. My recollection. My notes have it as they're wrong. It happened on the way back. This happened on the way back, and it's being taken out of context as if Mr. Molitor is already aware of a mission. He's not. And this is not representing the facts at all right here. These are misrepresentations of the time that this occurred.
Any facts related to the weight of the exhibit can certainly be examined on cross-examination. Do you have any objections or other questions?
I would just object because they just characterized this as happening on the way up and not on the way back.
Well, again, if there is an error, that can be pointed out, and certainly I think the jury would give that weight. So I'll leave it to that. Do you have any objection other than that?
No,
Okay. Any objections will be overruled. 134 and 134T will be admitted.
Thank you, Judge. Now, you just heard Mr. Barnett say this was on the trip back, Agent Influence. It's on the trip up or the way back?
This is on the trip up, and this is 1 minute following the previous clip we just listened to.
Thank you. Go ahead, Adam, if you would, please.
What is it? Well, here is a piece of If he can't, say, all right, this one, this one, this one. Okay? Like, if that's where it is, like, we're, before we even say on there, you can't even get it. So, it's gotta be good, because I had, it's gonna be, it's gonna be, so, it's going there, it's probably, it's probably, there. I'll be right, got that. It's going to be very fun. Open the day, you don't need something, you function. When we use the bag, they bring it all that. Oh, and it's off the frost and told that Thursday. I'm ready to go out here. That's it, that's that. Should go down and fuck, go down and go like we fuck this. Fuck, ground, so. That's I don't care, I don't say. We ain't got it all the time playing. We're just going out the fucking shake it out and fucking off. Can't wait it. I mean, it's always should you already keep saying that it's always just look at it. I know that. I know should be stupid. I mean, wants to be. I'm not saying I'm going to get it. So I just see what I'm listening. Just let me know, like, I didn't tell them instantly. They want to put something false in my mouth. And let's be all for sure that we can use the
Hey, Agent Impala, the reference to the dance there, what is that?
The dance or the big dance?
Speculation.
On terrorist investigations.
Yes.
Okay, can you tell us what that means?
It's objecting, Your Honor, speculating.
It's a code word for the boogaloo. The boogaloo is also a reference to a electric dance from like the 70s. And so another code word in addition to big igloo and the big luau is the big dance. So references to the dance, the big dance, the rehearsal, those are all references to the Civil War.
And Agent Impala, in your duties, as a special agent with the FBI, do you have occasion, like on this day, to conduct surveillance?
I do.
Is surveillance valuable?
Absolutely.
Okay, and tell us and give us some examples in what way.
So when you're conducting surveillance, you can see the subjects and the locations in the environment that they're existing in. So you can see the neighborhood activity, you can see how the community reacts, you can see lights, you can see traffic patterns, and then during the day, you can clearly see the surrounding homes. So you can count off and see how many driveways down, where the target residence is. You can make those types of observations that you can't make from looking online.
You familiar with proposed exhibit 135?
I am.
What is that?
This is an evidence photograph of a radio frequency and infrared light detector.
And where was it recovered from?
It was recovered from Eric Molitor's car.
Okay. And was this discussed at all on the daytime surveillance or any time that Mr. Molitor was with Mr. Fox that day?
Yes. So initially here in this time between 1 and 2 on the daytime surveillance timeline, when CHS Dan and Adam Fox went into Eric Molitor's home, Eric Molitor showed them the RF detector.
What does it do?
The RF detector portion of it detects radio frequencies, so anything that transmits, such as a cell phone. And then the IR detector.
I'm going to object without a foundation of the expertise as to this device. It's qualified to say what this device does and not receive any report from the FBI that anybody navigated it.
Mr. Ralston, if there's any additional foundation.
Sure. I just, so is he saying you have to be an expert to use this device? I'm trying to understand his objection.
We have the attorney. Mr. Ralston, you're placing additional foundation as to the agent's knowledge.
Sure. No problem, Judge. Agent Impla, are you familiar with this device in your work?
I am.
When you see such a device, does it concern you at all?
Absolutely.
Tell the ladies and gentlemen of the jury why.
Well, when I heard of this device, I was worried that it would put undercover agents and CHS Dan in danger. So I took the specs or the cut sheets of the device, I researched it, and I sent it to technically trained agents in our office. And I asked them if this device had the capability to put our undercover agents and sources in danger.
Objection, hearsay, coming around the corner, Your Honor, sorry to interrupt, agent.
I think we're going to foundation now for the relevancy of this device. And I think what the agent just offered, even if you excise the part about sending it for, additional information, is enough to allow the admission of the exhibit.
And what he was saying, the objection as far as anything else that he researched that you did, agent. Sure.
So setting aside whatever the technical folks in your office told you, did this concern you at all that now this device was in play?
Yes, absolutely.
Okay. Now tell us what it does again.
So the radio frequency detection.
Unless there's foundation of personal basis.
Mr. Ralston, perhaps we can begin with how this is.
Sure. Can you explain to the jury how you know what it does?
Sure. I typed this model into Google and I found this device, and then I downloaded the.
Google is not an authority.
Okay, ladies and gentlemen, hopefully the lunch will be delivered shortly, so we're going to take our afternoon break for lunch. All rise for the church. my seat. What I'm going to do is take a break and come back to this particular issue after lunch. But I want to let the parties know about a couple of things that everyone needs to keep in mind. And point your fingers at anybody if you share all comments for everyone. Admissibility issues pursuant to 104 don't take into account the rules of evidence when a court makes that determination. The other part is I will leave whether an answer to a desired question is more or less beneficial for a particular party than not. That is up to everyone to decide going forward. And we will deal with this, like I said, when we come back from lunch. It is 2 o'clock. That's sufficient amount of time for everybody.
Yes.
I just, what time you're at? 2 o'clock. That'd be absolutely fine.
Okay, then we'll take a break and come back to 2 o'clock.
Thank you, Judge.
I'm sorry, hang on.
The agent has testified 4.5 hours, 4 hours, 20 minutes off, almost 40 minutes off, 4 hours, 40 minutes off, implying that my client had prior knowledge because he said this happened on the way up, and he's, you know, you in on a mission, which would imply Mr. Molitor's known about this all the way up here. He knew nothing. 4 hours off, it happens, it appears in 16-53-36 at 9:40 into that 20-minute clip. You win, it's on the way back. How do we change this? The jury's heard that. It's critical that be changed immediately, that these folks listen to this. I have to move for a mistrial on this. They have just put this so far out of context. It's so unfair. And if I got chippy, I apologize, Your Honor. It's so infuriating to hear a professional agent tell us that it happened on the way out when it didn't. I heard it yesterday in the office. I see my client's notes. This happened on the way back after it happened at the commission. How do you go through all those details? We just hopped in the car. Here's Dan.
Okay. You can actually just run it in 16 minutes perfectly fine. So and again, for the purpose of the record, the jury's out of the courtroom. So help me to understand if I understood the testimony correctly. We played the initial clip, which was 133, and then 134, I think is the clip you're referencing, Mr. Barnett.
It is. I have the numbers. I could look this up and maybe we could fix this without a mistrial, but I have to ask for that based on the.
Okay, well, let's figure out what happened. The agent, if I understood you correctly, chronologically in time, 133 is on the right up, meaning from southern Michigan to Whitmer County, is that correct?
That's correct.
When did 134 take place?
So I have here in my records that 134 took place at 12:37 and that 133 took place at 12:36. But it could be a typo. I'm happy to review it and determine when it actually happened.
Let's take a lunch hour and let's do that. Okay. All let's go back on the record in 22-565-FH. Coming back from lunch. A couple of things to tie off. When we left, there were a couple of evidentiary issues we need to talk about. The first deals with this company transcript, exhibit 134 and exhibit 134.
It encompasses the letter.
A couple of evidentiary issues. The first deals with exhibit 134 and the associated transcript, which is exhibit 134T. There was a question as to timing. If I recall the testimony from the agent, it was a minute or two after 134. It's a minute or two after 133. Mr. Barnett objected to that. His notes indicated that I believe it was 5 hours.
Just under 5 hours, Your Honor.
Okay. A 5-hour difference, which would have been the trip back, to my understanding, as opposed to going up. And talking to the parties, they were able to review that clip and review their notes. And Mr. Ralston, it's my understanding that Mr. Barnett was accurate, that it was from the trip down at a different time. Is that correct?
4 hours and 26 minutes later, that's correct, Judge.
Okay. So as I told the attorneys, what we do when the jury comes back in, I would simply let them know of the issue. That his testimony previously was inaccurate, that it was nearly 5 hours after on the road trip back. Mr. Ralston, if you choose to correct the testimony, that's perfectly appropriate along with that instruction. Mr. Barnett, is there any other curative instruction at this stage? We'll get to mistrial in just a moment, but if that's not done, any other curative action you would like to see?
Is that the curative action for both wishes to take at this time?
That's the one that I would propose. I don't think it would reach manifest necessity for a mistrial at this point. I think that, and I understand the concept of, and I think I even said it earlier in the case, of not being able to unring a bell. But I certainly think that if they're instructed by the court as to the error, I don't think that the thought lingers in the head. I think that the person would acknowledge the change. So I think that step does remedy the issue and will be correcting.
Okay, thanks, Ted. Calm down, you think about this a little bit. Just think, uniformly requested that Mr. Molitor's case be dismissed for the prejudice that just happened. Our entire defense was, he doesn't know anything about this when he's getting in the car. And what was testified about was that 1 minute after, maybe 2, that he's been in the car, he's getting the issue of omission broke. And then right in, where he gave his conditional response. That's the crux of our whole case, and it's been bumped from the way back, way back down, from Elk Rapids, back to Cadillac, that's when it occurred. And it was stated clearly twice, once before the exhibit came in, once while the exhibit sitting in front of the jury. But that is so prejudicial, I don't know how we unring that bell ever. And they've heard this, they've heard it from the same witness, they're gaining trust with this case is going on. Now they're 4 hours and 26 minutes off. And they put it so far out of context, I don't know how the jury, in your mind, I don't know how they're going to handle this. We might be able to unring. I don't know that they can. And that's something that's so critical. We're at the heart of our whole case, which he didn't know what he was getting into. He's stuck in the back seat. Needs no pre-notice. And the context in which it did occur, which was afterwards, and why he said what he said. He will be testifying about this. But in this trial, is secondary to actually the dismissal. In fairness, you cannot erase this prejudice from the jury, and I would ask the court at this time to make that rule. Yeah, this excuse would be extended.
You know, I understand the court's position regarding correcting this error, obviously in favor of that. But, and that was over an hour ago, maybe over an hour and a half ago. And so putting it in context, I think, and I'm not doing Mr. Barnett's case, but I think they should be able to at least view the exhibit, not go through the whole thing by way of audio, but at least go through the exhibit so they have context of what came afterwards as opposed to what the agent testified came before the trip up. So I think letting them look at the exhibit will provide context regarding the statement made by the agent. And I would suggest that for the court and for Mr. Olson, because it's giving context instead of saying, oh, by the way, he made a mistake, he was on the trip back instead of the trip up. With the amount of information that they're getting, I'm not sure if they're taking hold of, what's up or what's down at this point. And so maybe showing them the exhibit, to take a look at it, so they can assess it themselves, the importance of it. And I'm just offering that as a suggestion. Thank you.
Let's appreciate it. Mr. Sauer, anything, please?
Yeah, I just concur with Mr. Nunzio as well as with Mr. Barnett. I think it's highly prejudicial.
Mr. Burnett, anything else?
No, thanks for hearing me out. I appreciate the court's indulgence, and I appreciate the prosecution double checking, and finding that there was a severe error, or my words, severe error made here that I think was fixable.
Mr. Wilson, anything?
I think the question before the court is, is there a manifest necessity for this trial? And, essentially the definition of manifest necessity is there's nothing we can do to correct this error that's occurred during trial. And that's not the case here. There is. And there's two things that are going to happen. You're going to instruct a jury, and I'm going to go through it with the witness. So no, there's no manifest necessity.
Well, I certainly take to heart Mr. Barnett's point. I understand, especially given the case that he plans to put forward, the impact that something like this could have. I also appreciate the suggestion from Mr. Nunzio. Context is important. So I think what we'll do is this. When the jury comes back in, we'll play 133 again. And then, so they could be ready to do that. And then at that point, I will instruct them that 134 is the exhibit that was played. It was testified to that this occurred a minute later. Mr. Barnett objected to that. And then it was researched over lunch and determined that that was incorrect, that it was 4.5 hours later almost on the trip back. But so that they understand the error, we're going to play 134 for them again so that way they hear both exhibits again. They understand the error where it is in the court's mind. That is sufficient, though I do take to heart the arguments made by Mr. Barnett and the attorneys. And certainly, we've talked about manifest necessity a couple of times today, and there can be a cumulative effect. Hopefully, we don't have that issue. That certainly isn't. So, Mr. Nunzio, anything else for you?
No, thank you, Your Honor.
Mr. Sack?
No, thank you.
Mr. Barnett, anything else?
Is the court going to address this at the end of the case too, as we speak to the jurors, or is this going to be taken care of now?
Well, I guess the corrective action being taken now by the court is what will be taken today. When we talk about jury instructions and whether anything else is necessary at that time, certainly a party can request that and we can get out of that.
Thank you.
Anything else for you, Mr. Wilson?
No, sir.
Okay. All rise for the jury.
I didn't come on back on that lunch. We need to take care of one evidentiary issue with you all. If you recall, there was two audio files. There was exhibits 133 and 134. You heard those previously, and it was testified to that exhibit 133 was audio from inside a vehicle as it traveled north, and then the testimony was that 134 occurred within a couple of minutes after 133. And Mr. Barnett objected to that. He disagreed with the timeline that was being presented to you all. It was testified to again that it was a couple of minutes later, I believe. And I did do research during lunch and listened to it. It is determined that was an error. And so, as Mr. Barnett objected to, and the information he provided, which was that the second audio clip meeting exhibit 134, that took place approximately 4.5 hours after it was previously testified to. As Mr. Barnett indicated, it was on the ride back down, not the ride home. Okay, so I want to inform you of that correction. The other thing that we're going to do is play both of them again for you so that we can properly take in the context of that error. And then obviously this is one of those things where I instructed you in terms of the weight of the evidence that you give it, credibility, those kinds of things. This is an example of where that fits in. Okay, so we'll play 133 first, please.
Okay, let's get into of the group who works in Washington. Okay. We have over, we'll see for what, You know what I mean? Another lesson tell you. I mean, you know what else water next year. You don't need to have open when you said we're going to have remember there in the stands.
Okay, so that was exhibit 133. You can recall the corrected timeline is exhibit 134 was not 2 minutes later, but it's 4.5 hours later. Okay, to 130.
What is it? Here is a piece of no, it's not what we see. Some people like my guess is the part see the smaller things. And whatever, and fucking say, all right, this is over, this one, this one. Okay, ready. That's where I found the right word before we get it's gotta be doing. It's gonna be done. It's gonna be got now. So it's gonna be like what's it become with that? Yeah, we're gonna have ads all this. We're gonna it's very fun. That snap slap, that snap right. I don't care about all that. We need to have an all play. We're just fucking shit out and fucking off. Can't believe it.
I mean, as long as you keep saying that the person is opposite, it's just so bad. I'm just letting you know, look, I live in intelligence, they all say right now.
Leave that up there if you would, Adam.
So does everyone understand the error that was taken correct time? Mr. Ralston, go ahead.
Thank you, Judge. Agent Impla, during lunch, did you go back and scrub the times?
Yes, sir.
Okay, and did you discover this error?
Yes, I discovered a typo on my timestamp for Exhibit 134.
Okay, and Mr. Barnett was correct, is that right?
That's correct. Yes.
Okay. Now, you told us before lunch, this is what was said almost immediately on getting in the car, is that correct?
That's what I said, yes.
This is actually said after the daytime surveillance, is that right?
Correct. So on the ride home, after the daytime surveillance, this is when the timestamp is on this statement.
And that's after they've driven by the governor's cottage?
Yes, sir.
Okay, and after they've had, tell us about the different things that happened during the course of the daytime surveillance before Mr. Molitor says, dude, I'm in as long as shit, you keep saying like it's going to be done professionally. I mean,
Sure.
Tell us about some of the things that happened before Mr. Molitor makes that statement.
Sure. So this clip occurred at 5:03. So looking at the significant events timeline here. So all the way up to between 15 and 16. So the first 15 items that are on the daytime surveillance timeline, all of those events occurred. And then this statement was made on the ride home between 15 and 16 on the significant events timeline for the daytime surveillance.
So this happens, if I'm looking at the daytime surveillance timeline correctly, it happens after Mr. Molitor searches for Governor Whitmer's cabin address.
That's correct.
And it happens after the first drive-by of the house. Okay, does it happen after item number 7 in the timeline, first
Yes.
drive-by of the house? Does that happen after their discussion?
Objection, I'm sorry, make another objection, just ask, raises questions about a leading nature, referring to exhibits now, that's stated as well.
A leading question is one that suggests an answer. I don't believe that does, Judge. Did it happen after item number 7, the first drive-by the house?
I'll allow the question,
Yes.
And does it happen after they have lunch at the Red Bull Tavern?
Yes.
Okay, and item number 9, does it happen after Mr. Molitor searches for Governor Whitmer's address?
Yes.
And does it happen after item number 12, after the second drive by the governor's home?
Yes.
And does it happen after items 13 and 14, the activity at the boat launch?
Yes.
Okay, so when he says, dude, I'm in as long as shit, you keep saying that like it's going to be done professionally, it happens after all those things actually, correct?
Yes.
Okay, very good. I'm ready to move on to, we were on exhibit 135, I believe.
I hate to interrupt Mr. Ralston. We're an exhibit with a timestamp on it that's incorrect, Judge. How's that?
For the transcript itself.
Yeah.
We'll correct that, Judge.
No.
Sir?
Time on the exhibit.
There is no timestamp on it.
Yeah, there is.
See, mine, I don't see.
Okay, very well, that's right.
No, that's okay. Yeah, I'm missing anything.
No, sir.
Okay.
Exhibit 135, I think, is where we left off, and that was the proposed Exhibit 135, the photo of the radio frequency detector. I think you were telling us before lunch, Agent Impala, a little bit about that and how you learned about it. And you said that you researched on Google and Mr. Cyber.
That's a question, not a narrative.
Well, I think for that one specifically, he was simply reorienting the witness to the question. I understand the objection.
We'd ask him to ask a question.
Okay. Mr. Wilson, well.
May I continue? Okay. And again, I'm going to start over. When we were before.
I think we're good. We all know where we are now. He's been oriented to the question, so go ahead.
Okay, and you used the word Google, and then there was an objection by Mr. Cyber, and we ended there, I think. Where were you going on Google to research this device?
I was going to the manufacturer's website of RF detectors.
Okay.
To find the specs, which is the cut sheets or the equipment description of their capabilities.
Okay, and did you communicate at all with Dan about this device?
I did.
Tell us about that.
I showed Dan photographs of different RF devices and asked him to pick out which one it was, which he did.
Okay, and after identifying it, tell the jury a little bit about what you learned.
So I reviewed the capabilities and the specs from the cut sheet on the devices, and I realized that it was able to detect radio frequency signals, so anything transmitting.
We're dealing with multiple devices. You just said I reviewed all the devices. We need to know expertise about the device, not multiple devices.
Mr. Wilson, perhaps you have additional questions about this device.
I mean, once the device that you asked Dan to identify which device it was. Is that correct?
That's correct.
And then is that the device you went to and researched?
Yes, I researched only the device, which is this device right here, which is the one Eric Molitor had.
Okay. Yeah, thank you. And what did you learn?
So I learned it had the ability to detect radio frequencies. So that means if something is transmitting a radio signal, it would alarm. And then it also had the ability to detect infrared camera lenses. So if there's an
Your Honor, this is not what the manual says. It's a camera finder. It's not infrared.
Hey, Judge, that's not a valid objection. It's not a legal objection.
You can say everybody, hang on. Ladies and gentlemen, we're going to take a short break from speech from the courtroom. We can do this with 2 minutes and we'll be right back. Okay, everyone can be seated. Pleasure to invite the jury's out of courtroom. Mr. Barnett, you got it.
Judge, I'd like to see the manual he's looking at. This does not have an infrared. It's not an IR. It's got an IR, which is what we're talking about. That's valid. There's no infrared detector. It's supposed to. It's $50 item. It's supposed to find camera lenses.
And that's why I just took a page of testimony.
But he said infrared. That's a whole different thing. Like for radar, a light spectrum will come low for lights that it picks up. I believe in terms of that. But this is not infrared. This is a lens. If we had, his foundation was what we looked at on Google, would help us. And I just want accurate testimony. I apologize for stepping in again. It's all fast.
So the testimony was that you looked sketchy for this device from the manufacturer, is that correct?
Yes.
Okay, and that's what your testimony is based on?
Yes.
Okay. Other than the testimony of what the company said that you do, I don't know what you're anybody else would do with the testimony.
Which I think what Mr. Barnett is getting at is he hasn't identified the item. This could be a Sony, this could be a Panasonic, this could be a Emerson, we don't know what device it is. We don't know the model number. We don't know what he's looked at. And there's no foundation laid. And this is a major issue when we're coming down to this type of piece of equipment. Mr. Barnett is trying to make sure that we don't have to give another curative instruction or another correction to the FBI system. It would be a second one today. Thank you.
Mr. Neal, do you have any conclusion?
Nothing, thank you.
Mr. Barnett, anything additional?
Just on our GS detector, whatever GS is, we weren't reported to have the manual or whatever he looked at, be prepared today. I would ask that we move on to a different area and come back with the, whatever he looked at. I think we're going to find that there's another error occurring here and overstepping.
Very well.
Maybe heard, Judge.
What's that? Well, I think Mr. Alston said, what the court will allow is testimony of the witness insofar as what he did. He testified that he researched this particular device by going to the company's page and looking at the spec sheet for this particular device. I don't know that we need the model number and referencing photograph to say that it's this particular device he's looked at. If it turns out that that's wrong, then we'll go from there and it needs to be corrected, fine. If we get to the level or to the point where we're at this trial, it's fine. But the court can only deal with the testimony that has been presented. And so it's my understanding that the research you did is relative to this device in particular. Is that correct, Agent?
Yes.
Okay. Anything else for you, Mr. Ralston?
Yeah, just I'm going to weigh in on this issue, Judge, not in this particular issue, but overall. The objections that are coming here are really, they're not legal objections. It's not, based on a rule of evidence. It's not based on case law. I mean, the attorneys for the defendants are using this opportunity essentially to do two things. One, cross-examine the witness, which is, it's not appropriate to do that now. And two, to also make arguments for the jury. And I'd ask the court to curtail that. I mean, that's, these talking objections are arguments that are being made for the benefit of the jury, not because they're trying to enlighten the court as to a legal reason why it shouldn't be allowed.
Mr. Johnson, anything for you?
No, thank you. Just, Judge, I still haven't heard any foundation of who made this device, what's the model number, anything like that. I looked up the device, but it's real general. We need a specific. If he's not an expert, I need a specific on what the model number was, who manufactured it, what website you can go to. Can I do it right from my computer here? He's not giving us any information that we can go and find. It's all general. So we'd ask the court to be foundational and be specific. I guess the counsel's looking for an objection. It's number one, relevance. Number two, lack of foundation. Thank you.
Mr. Barnett, anything else for you?
I think we said most of it, and I appreciate the court putting up with minor this fun and have a clear record here to help have a fair trial, provide steps here. And I'm just telling court that this is not an IR. I'm not telling the witness, and I'm asking that we have a moment to look at the manual so we can go out here and we can
Well, the notes that the court has heard relative to this, I understand relative to admissibility, relevance the court has talked about previously. In terms of foundation, the agent testified that he looked up the spec sheet on this particular device after it was identified for him. The one that's identified in proposed exhibit 135. He testified as to how he got that information was from the manufacturer's website, what the manufacturer's website is, as well as the name, make, and model number are not necessary for the admittance of this photograph. The key is whether or not it's a fair and accurate representation of the device that was found, as well as his ability to, the basis for his ability to answer questions on the capabilities for it, and that is from the company website itself. So unless there are additional foundation questions.
What company? We need to be able to go find it on the computer right now. We need to know what company.
Can I help?
We know what model number.
Do you know the company name and model number for it?
I found it on Amazon. I don't know the company name, but it's published in Amazon under the review and the cut sheets can be accessed through the website from Amazon.
Let's take a moment and get that information, Mr. Secretary.
And also, in the discovery we provided a picture of the box it came in with the name and the manufacturer on it. I mean, so it was in the discovery. Oh, no, it was in there. And
Have it, Mr. Wilson, you can have the
Thank you.
information to you.
I don't know. Why don't we take 10 minutes, Judge, to, that's it.
Thank you.
Thank you.
We'll be in
Thank you very much.
until that's-
Appreciate your patience.
Are you making the bench or are you saying?
I'm saying.
Thank you.
Step out here, is that?
Yes, sir.
This is the Amazon that I recall.
What's that?
Yes.
This is, like I said, it's not. Right. It says GPS unit on it.
I think what he said was that that's not the exact one. Not able to go back and do his internet search from the time he got his hands on storefront and wanted to look. Is that correct?
It's correct, but it just is actually the unit.
Oh, that's.
And I did locate the exact unit from the box. And
Okay.
this is the spec sheet, the cut sheet from Amazon that I found. I can't tell you if it's the exact one from 3 years ago.
Sure.
But I recall seeing this unit, this box, and it was the same one we ultimately found in the house.
Yeah, you want? There's enough. If you want to use that. The box for the RF device still resides at my client's home. They have their own box.
Okay.
So I want everyone to know that. I can bring that up, bring it on the table here, show everybody. We're not hiding anything in this case, but that is not the right one. It has a GPS unit attached to it as well. I believe, just as an officer before, our device would have RF. It would have spy camera. It's not infrared. It's some kind of lens thing. It's, it's $50. It doesn't work. It's a toy, but that's what it says. It doesn't have GPS. It doesn't have infrared. It misinformed the jury again today, twice within a short
If I may, this does not have GPS. This is to detect GPS on your car.
Okay.
So this unit here does not have GPS.
I apologize. It says it detects GPS. Maybe I'm trying to catch up here too. I'm behind catching up, but we have a box. We put that to bringing it in. They didn't take the right box. So they have evidence that it's not attached to this. And I found 6 different K-18s on the internet, and you can't, you want to look at one of them, the odds are 1 in 6, you're right. Maybe he's right on, I hope he is, but there's no infrared. That's been told to the jury. There's a camera, hidden camera device that's with my remembers that we opened the honest about this. And it has our capabilities.
So I'm going to turn the laptop and you see. Go ahead, sure.
Thank you. That's, this is, I want to have a straight statement to the jury, fair trial. And I apologize, Mr. Ralston's mentioned, but just, can we stop this misinformation before we have to stop the problem? I just don't think that's fair.
Mr. Nudd, do you have anything else?
No, thank you.
Mr. Secretary.
No, thank you, Judge.
Okay. Mr. Wilson, anything else?
No, thank you, Judge.
Okay. So I think where we left off was the proposed exhibit 135. This photograph fairly inaccurately represents the device that was located. Is that correct, Agent?
Yes, sir.
Okay. The agent was also testified as to reviewing the section for that device, testifying to its functions. That's where the objections occurred. Any further objections to note on the record, Mr. Dungy?
I'm sorry, did he take the specs off the picture, off the device or off of a box that the device was presumptively in? I'm really
The
confused.
spec sheet, if I understood the testimony correctly, the spec sheet came from the Amazon page for the device, which he looked up after it was discovered. The box was located in Mr. Mauer's house.
Okay, so, I'm sorry.
I just want to make sure I'm right.
Yeah, let me restate that to make sure I get it right. So initially, when I heard of the RF detector, performed a search, I saw it on Amazon, I had CHS Dan identify it.
Which one? You had CHS Dan identify which device you need?
I had him identify the Amazon device that I just showed,
Okay.
and he positively identified that as resembling the one he saw in Eric Molitor's house. And then that's the one that I thought it was. And then following the execution of the search warrant in October, we located a device and we took pictures of a box of a device in the house. And the box that we found in the house and the device that we found were the same ones that Dan had positively identified.
Is the one that you found in the house the one in the photograph of the proposal?
Yes.
Okay. Mr. Dungy, anything else?
I think you asked the question, so the one that Dan identified is the one in exhibit 135.
If I understood the testimony, it matched the model that he saw.
Okay. Okay.
That's correct, yes. We didn't have this yet when Dan had positively identified it. It matched it, and then later we found it. This is the evidence photo.
Okay, thank you for the clarification, I appreciate it.
Mr. Sadler, anything else for you?
No, Judge.
Okay. Mr. Barnett?
Yes, I would point out to the court, it does not have infrared capabilities as was previously testified about. It has GPS and RF. This thing didn't have GPS. It had a hidden camera and an RF. And whatever the hidden camera means, it's not going to be anything in the GPS, it's not going to be that. It's certainly not infrared. So they're putting in something in Ken that's not accurate. So we just have to the county, we asked that we put a saw on this and not create.
Well, there's two components to this. The first was the photograph of the device in proposed exhibit 135, fairly and accurately depict the one that was found when the search warrant was executed. So that's one part. The second part of this doesn't deal with 135 or proposed to 135. It deals with the testimony of the agent as to the capabilities, which he learned by reading the section. So let's deal with those two things separately. In terms of the photographing and
Just so I'm clear with this, please forgive me, thank you for your patience. Because this is a device that was purportedly used, okay? Is this the same device that was purportedly used, or is this something that was recovered at a different time? And again, is Dan saying this was the device that was used in the capacity because the agent had testified before? That's my question now. Is it the same device that Dan is saying that was used? Or did they just pull pictures of devices to see what they were capable of doing?
So we learned of one RF detector, but I didn't know which device it was. And then when we executed the search warrant, we found one RF detector.
So if I understand the testimony, it may not be the same device. So I would then argue that it can't be admitted.
But the testimony was, as I understood it, that what the agent did was so CHS Dan, that's how you learn that there is an RF device, is that correct?
That's correct.
And then you showed him, was it different models and he picked one out, or how did that?
I selected different photographs and I showed him the different models and I asked him to identify which one it was, which he did.
It ended up matching this one.
That's correct.
Okay.
Can I make a suggestion? I understand that CHS Dan is testifying.
Sure.
Holding that into abeyance, is Dan going to testify that the exhibit 134 is the same device that was used in the detection of whatever was used to detect? I said, we don't have that information right now.
Well, what's been testified to so far is seeking to admit proposed exhibit 135 because that was the device that was found in Mr. Mahler's house, is the way I understand the testimony. And then secondly, along with that is the testimony that is sought are the capabilities of that device, especially as to the radio frequency.
One last question. Were any other devices found in this house similar to that?
Any other like RF style devices? No.
No more questions. Thank you.
Sir?
Very briefly, Agent, did you see the box at Mr. Molliker's house?
I saw a photograph of the box.
Did you see the box at his house?
I wasn't at his house.
Judge, we'd say that the box which they have is the best evidence. As I'll give it for Mr. Barnett. The box is the best evidence, Judge. Not his testimony, not anybody else's testimony. The item and the box. We have the box. It's the best evidence.
Okay, is there something about the box or what the agent read on the box that's called into question?
Yes, Judge. The specs of the item. Mr. Barnett brought in multiple objections to the specs of the item. The box has the specs on it. The box is the best evidence, and we have the box.
Correct, but best evidence will only apply when there's a challenge to the, if there's a photograph of an item and let's say it's a photograph of the writing, and the writing is not challenged or the contents thereof.
It absolutely is, Judge.
What about, Mr. Sider?
Yes, sir.
What about the information on the box has been changed?
The information on the box that has been challenged is GPS. This agent has said this isn't the identical search, but this is the similar item, and he's testified that it's GPS. Mr. Barnett has said, no, it's not GPS. The box is the best evidence since we have it. There's not an IR detector on it. This is, or Mr. Barnett.
Multiple times. So, Mr. Barnett, anything else for you?
Just that the IR has been misidentified or testified about and raising the, what this device does. It doesn't do that. It's supposed to detect hidden cameras just from our side, and it's an IR device.
Mr. Rolfin, are you going to seek admission of people's proposals to the 135?
Yes, please.
Let's talk about any other objections other than what we've done.
No, thank you.
Mr. Sider?
Just first hand is that.
And Mrs. Barnett?
Just in case, for sure. But I'm fine going to testify and probably identify this item. Maybe spares everybody that he would. I'd probably identify this as his and take this link, but it does. And we will bring a box and they can send a policeman to leave his mom to color. If you can just get the box today, don't worry about the camera. You've got a box, and match the picture, and it'll say, you can say anything for that, which is my whole point. I'm sorry, that was all I wanted to know.
Well, let's not kick a horse more than it's been around about 30 feet back. So as to the photograph, which is People's Proposed Exhibit 135, the court will admit that exhibit. There's testimony with that device that was found, and that is the basis for that photograph being admitted and fix that test. In terms of testimony relative to the capabilities, the court will allow it in terms of the RF function only. That should address any of the concerns that we had today, and the testimony will be good for that.
Understood.
Okay, Mr. Nizzi, anything else? No, thank you. Mr. Sack?
No, thank you.
Mr. Barnett?
Oh, Your Honor, thank you very much.
Okay, all rise for the
Yeah, go ahead. Be 2 minutes. Thank you.
So that was a time for a sidebar.
Good night, sir. Yes, record.
Thank you very much, Judge. Mr. Impla, when we left off, I think we were talking about proposed Exhibit 135. Are you familiar with that?
I am.
And can you tell us what that is?
Yes. So this is a radio frequency device that was found at Eric Molitor's house following execution of the search warrants on October 7th, 2020.
Okay, and what does it do?
It detects radio frequency transmissions.
Okay, when you, in terms of your live monitoring of the daytime surveillance, did you hear discussion about this?
I did.
Okay, and tell me, if you will, if that alerted you in any way to potential, safety issues with either the undercover agents or CHS Dan.
Yes, it did.
Tell us about that.
It caused me concern that my ability to monitor live transmissions at trainings could be compromised because this device could be used to detect the transmitting devices on undercovers and sources.
Okay, move for admission of 135, please.
Subject to the other discussions we had, anything else?
Nothing further, thank you, Judge. Should we just stand on our statement, Judge?
Mr. Bynum?
No objection.
Okay, 135 will be admitted subject. Objection.
Thank you.
Not side.
Agent Impla, what does the long extension from the top of the device do that's in a horseshoe shape?
That's a wand that detects radio frequency transmissions.
Okay.
I'm going to check your own further. Unless there's a foundation here behind looking something up on Amazon.com.
Thank you, Judge. Agent, I'd like to draw your attention now to proposed exhibit number 136. Are you familiar with that?
Yes, I am.
Can you tell the ladies and gentlemen of the jury what that is?
So this is an audio exhibit. It's an audio clip from the car ride on surveillance with CHS Dan, Adam Fox, and Eric Molitor. And it is as they're just prior to identifying the governor's residence on Birch Lake.
I'm going to move for, is there an associated transcript marked 136T?
There is.
And is that transcript accurate as to the audio?
Yes, it is.
Move for admission of proposed exhibits 136 and 136T, please, Judge.
Mr. Side.
Please stand on our objection.
Mr. Barnett.
No objection.
Both will be.
Agent Impla, is that in fact the address where Governor Whitmer had her cabin?
Yes.
Okay. And tell me if you're familiar with proposed exhibit 137.
I am.
And what is that?
That is an audio recording of the car ride, the surveillance when Eric Molitor, CHS Dan, and Adam Fox see her house for the first time and positively identify it as her residence.
And is there an associated transcript with that marked 137T?
Yes.
Does that transcript accurately reflect the audio?
Yes.
Move for admission of 137 and 137T, please, Judge.
Mr. Side.
Please stand on your objection.
Mr. Barnett.
There's a mischaracterization as the first time, and I'll take care of that across.
Okay.
No objection.
Both will be admitted.
Thank you.
That's it. That's it. That's it. Fuck it in. That's it. All right.
have the effect of hearing the voices as not Eric speaking, that was Dan. Every time it's at one, when my client and say anything between, that's it. It's like, voice of one show. If they made on the transcript, I'm sorry to see the survey, but yes. You can open that up for 1 year, or that is bring to change the name.
Well, the meeting has specified previously as to how we reach those determinations. If you believe that there are errors, you can point that out in class-examination.
Thank you, Judge. Let's turn to 138 if we could. Familiar with that item?
Yes.
And what is proposed exhibit 138?
This is a photograph from Adam Fox's phone, which is also posted or sent to CHS Dan. But it's a photograph from Adam Fox in the passenger seat, looking across CHS Dan towards the governor's residence.
Okay. And move for admission of 138, please.
Mr. Sack.
It's getting out of our compliance.
Mr. Hart.
No objection.
138 is
What are we seeing there for the record, Agent Employ?
So this blue cabin cottage here, this is the governor's residence. And the car here is headed south on Timberlake Drive.
And who do we see there, the gentleman in the left-hand portion of the picture?
This is CHS Dan who's driving this truck.
Okay. And this is on August 29th, 2020. What date is this, Agent Employ?
This is the date of the daytime surveillance, August 29th, 2020.
Okay. The driveway to the governor's, put that back up just for a second there, if you would have, thank you. The driveway there to the governor's cottage, how close are they to it?
My estimation is about 50 feet from the road here to the front of the cabin.
Okay. If you can, proposed exhibit 140, can you tell us what that is?
Yes, so this is another audio clip. And this is the car with CHS Dan, Adam Fox, and Eric Molitor. And this is as they're driving up and down Timberlake Drive.
Okay. Does it have an accompanying transcript marked 140T?
Yes, it does.
Okay. And by the way, you said you've listened to the 150 plus hours of audio in this case. Is that correct?
Yes, sir.
And can you distinguish between Dan's voice and Mr. Molitor's?
Yes.
Okay. Mr. Barnett suggested a few minutes ago that that was Dan speaking in exhibit number 133. Was that Dan or Mr. Molitor?
Well, I did the best I could on the single syllable kind of grunts or O's. I thought it was Eric Molitor.
Okay. And on 140, same thing. What's your level of certainty as to the attributions to Mr. Molitor in that transcript?
I'm confident that what we have on 140 as Eric Molitor is what he said.
And does the 140T, the transcript, match the audio?
Yes, sir.
Move for admission on 140 and 140T, please.
Mr. Munter. Mr. Sack.
This is a Blackie Foundation.
Mr. Austin was incorrect. He said 133. I think he meant 137, which was addressing patient info alcohol, the voice issues, and the issues which exhibit it was, just for the record. 137 is the one. So, not 133.
Any objection to the admissibility of 140 and 140? Okay. The court believes that the agent has properly identified the audio as well as the transcript that's associated with it. So they both can be.
Thank you.
Yeah, see, go back down this or they don't know that progress. Yeah, but it's all about that. That's it. So they're better get on whatever. Yeah, very so. They're good about it, saying out there, pull out and shit like that. Whether compared to this.
And can you read into the record the last sentence Mr. Molitor says there?
Yes. Eric Molitor said, yeah, you don't know what risk is.
Okay, thank you very much.
And I'd like to write to reflect the sentence after that, and something like that was interrupted. That wasn't the last sentence. Mr. Monitor's sentence, whether it was interrupted or not, there was another sentence that played. It's not on the transcript. Okay. So, Mr. Wilson.
Thank you, Judge. Going to, if you would please, proposed exhibit 142. Can you tell us what that is?
Yes, so 142, so this is the fifth audio recording from the daytime surveillance on the August 29th. And this is also Eric Molitor, Adam Fox, and CHS Dan. And they're, at this point in time, they've pulled into the parking lot at the Oasis Red Bull Tavern, and they're getting out of the vehicle, and Eric Molitor and CHS Dan are benching their weapons.
Is there an associated transcript marked 142T?
Yes.
That transcript accurately reflect the audio?
Yes.
Move for admission of 142 and 142T, please.
Mr. Simon?
It's staying in our written objections.
Mr. Whitmer?
What areas to timeline and context?
Well, I think the timeline is from when they pulled into the establishment.
Context.
I don't know what that means. What do you mean?
I just have one question relative to the context of this, but I can't give you that. There's a discussion before this, Your Honor, but or after.
Okay, what's your question?
Is this a little segment here, is that after they talked about bringing up into the bar, parking served, diner, alcohol, 50%, is that when these weapons were done?
That this discussion here.
So I recall the discussion you were talking about CPLs, and I just don't recall if they had that discussion right after they benched their weapons or right before it. But it's certainly right around the vicinity, the benching of the weapons was a topic as they discussed whether they could carry in a bar.
Legally.
Correct.
Thank you. Okay.
Okay, 142 and 142. Okay.
How much you got? Just one out there. Do you use it? Everybody's still
A couple of questions. The last statement Mr. Molitor makes here is, and for the record, that was when I still believed in doing things the right way, correct?
Correct.
And this discussion, I think you indicated, is what are they talking about? What are they doing?
We're talking about his CPL and when and where you can carry firearms.
Okay. This is after they drove by the governor's house, correct?
That's correct.
Okay, and the discussion is Mr. Molitor benching his firearm.
Correct.
Okay. I'd like to draw your attention to proposed exhibit 160. Can you tell us what that is?
Yes. So this is another audio clip. This is the 6th audio clip on the surveillance ride between Adam Fox, Eric Molitor, and CHS Dan.
What is the general discussion going on?
This is a discussion about first responders, the location of police departments.
Is there an associated transcript marked 160T that's associated with this audio?
Yes.
And is it accurate as to the audio in proposed exhibit 160?
Yes.
Move for admission on 160 and 160T, please, Judge.
Please stand in our written objection.
Mr. Whitmer.
In a minute, Your Honor.
Just trying to figure out. 160. Here's the context again, reading this statements. Before or after the tavern.
So this is, let's see, the time that I have noted here is 3:41. So just after number 11 on the daytime surveillance timeline, which is after they depart from the tavern and then before they get to the house for the second surveillance.
Okay, so this is happening after the tavern.
Yes.
After Adam already wrote on a map that says the PD is 5 miles away.
Yes. That occurred on item 11, and this clip is right after item 11.
So.
Any objection to the admission?
No.
Both 160 and 162 would be.
Ideally, you know, questions behind it, and they're obviously foggy, right?
Other things you look at like the demographic in the area, how many police they have out at all times, because like even Grand Rapids, my judging instructor, he was the police officer, and he said even Grand Rapids, he was like they had one cop out at certain times. Yeah. So that's what crazy fuck that gives opportunity.
And again, for the record, the last thing Mr. Molitor says is, say that's fucking crazy, but that gives opportunity, correct?
That's correct.
I'd like you to turn to proposed exhibit 149, please, and tell us what that is.
Should we take the number again?
149.
Thank you.
Yeah, so 149, so this is now the 7th audio clip from the daytime surveillance with Eric Molitor, CHS Dan, and Adam Fox. And this is now after they've left the Red Bull Tavern, so after item 11 on the daytime surveillance timeline. And as they're going to be going by the governor's residence again.
So if I'm correct, may I imply or strike that? Did they drive down Timberlake before lunch?
Yes.
Okay. And did they drive down Timberlake after lunch?
Yes.
Which of the two of these is it?
It's after lunch.
Okay. And the content of the audio, can you generally describe it, please?
Yes. This is when Adam Fox.
Judge, the audio would be less than.
And laying the foundation for relevancy, Judge.
There are some foundational aspects that have to be described by the witness, which is why it was asked to do so in a general sense. Certainly the audio file, any discussion of opinion on to give us evidence, in terms of what on it, but it has to be, first of all, question and answer.
So this is a request from Adam Fox for Eric Molitor to do a slow-mo video of the governor's residence as they drive past.
Using whose phone?
Adam Fox's phone.
Okay. And is there an associated transcript, mark 149T, that is part of this audio clip?
Yes.
Does it accurately reflect what was said?
Yes.
Move for admission of 149 and 149T, please.
Mr. Sapp?
We stand on our objections.
Mr. Barnes?
I want to check, I'm just curious, I didn't catch the other exhibit that he had, is that a picture or a video of Dan? Sorry, Adam's book, is that a video clip or a picture?
We haven't gotten there yet, Judge.
With Dan's face, I'm sorry,
Oh, the picture.
is that a picture or was that?
Yeah, Dan's face, that was a picture.
Okay, thank you.
That was exhibit 138.
Yes, Your Honor.
It was not a video, it was a picture. I mean, I'm just wondering if you stop action on video and that.
So when Adam Fox takes pictures with his phone, he's got his picture settings to be what you call a live photo. So it takes 3 seconds of the photo. So when you pull up the photo, it looks like this, but it kind of moves a little bit. It's called a live photo. That's what this was.
Okay, so if you're driving by, it moves.
It moves like 1 second before and 1 second after the photo that's depicted.
Okay, but that was the stop action and the, presumably.
I'm sorry, I don't understand the question.
We have an objection to this exhibit coming in relative to the stop action.
Very keen to everyone. Use formal video real quick, put this up against that window there, and then press that button, it's formal video as you go right there. It's just that it's on somewhere out in the bottom, and then also I should record that slow video as we go by.
Agent Impla, are you familiar with proposed exhibit 150?
Yes, I am.
Can you tell the ladies and gentlemen on the jury what that is?
150 is the slow motion video that was taken at this time, which was recovered off Adam Fox's phone pursuant to a search warrant.
Okay. I'm going to move for admission of proposed exhibit 150, please.
Mr. Sapp?
We stand on our objections.
Mr. Barnes?
No, you're right. No objections. Sorry, Your Honor.
That's okay. 150 is the.
Agent Impla, are you familiar with proposed exhibit 151?
right, everyone can be seated. Welcome back, ladies and gentlemen. Before we go back to the prosecution case, we want to address the note that we received, asked how they work. Just in a general sense, you receive a daily fee, and then also mileage. Both of those amounts are calculated in the total at the end of the trial and then paid in full once the trial is. Okay, any questions for everybody? Rolf, something to go back.
Thank you, Judge. May I proceed?
Yes.
Good. Agent Impla, before we broke, I think we were talking about our Exhibit 1 or number 159. Is that correct?
Yes, sir.
And what number was that in the audio clips of the daytime surveillance?
159, that was the 11th audio clip of the daytime surveillance.
And these are in sequence in terms of chronological order?
Yes.
Okay, what is it followed by?
So it's followed by the 12th clip, which was 134, the one we discussed previously.
Okay. All right. If we can turn now to proposed exhibit number 141, can you tell us what that is?
141?
Yes, sir.
Yes. So 141 is a surveillance photograph, and this is CHS Dan, Eric Molitor, and Adam Fox at the Oasis Red Bull Tavern when they're after they've stopped for lunch, or excuse me, this one is shortly after they benched their weapons and were going inside.
Okay. Move for admission of exhibit 141, please.
Mr. Nunzio?
No comment.
Mr. Sack?
Good standing on recommendation.
Mr. Barner?
No objection here.
141 will be admitted.
What do we see there, Agent Empla?
So on the left, this is CHS Dan. This is Eric Molitor. And this is Adam Fox.
Okay. And the back tailgate of the truck is open. Is that correct?
Yes.
Tell us about that.
When they benched their weapons, Adam Fox had some marijuana, and I believe he put it in the back here.
Okay. And where'd the weapons go?
At least one weapon went in the glove box up here. I'm not sure if Dan put his weapon in the back or in the glove box.
Okay. Proposed exhibit number 143, are you familiar with that?
Yes.
And what is that?
This is a photograph taken by CHS Dan at the Oasis Red Bull Tavern. It's a photograph of Adam Fox drawing a map.
And what is the map of?
The map is of
Speculation.
Sustained perhaps some foundations.
Sure. Did you later come into possession of that map?
yes.
Tell us how.
Following the training, following the surveillance, Adam Fox gave CHS Dan the map, and CHS Dan gave me the map, and I entered it into evidence.
Move for admission of 143, please.
Mr. Nunzio? Mr. Sack?
Good standing on written objection.
Mr. Barner?
Who took the picture? If I may, Your Honor?
CHS Dan.
Okay.
Any objections with admission?
No, Your Honor.
143 will be admitted.
What do we see here, Agent Empla?
This is Adam Fox on the right here, looking at his phone and drawing the map.
Okay. Familiar with proposed exhibit number 144?
Yes.
What is that?
This is a photograph taken of the actual map that Adam Fox drew.
Move for admission of 144, please.
Mr. Nunzio? Mr. Sack?
Good standing on written objection.
Mr. Barner?
I next to, I can't read this. Are we gonna read what's written on the bottom of the jury? We just starting,
When you say bottom, I don't know what the word is.
there's Elk Rapids, PD, 3 miles away. Everything else, 20 plus miles. If that's what it says.
Okay, do you have
It's
any objections?
explained to the jury, I have no objection with this.
Okay. 144 will be.
What do we see here, Agent Empla?
So on the left, this is a rough sketch of Birch Lake. Facing north is up here. Williams Road down here is south. And this is 31. And then on the right side, facing the other direction is handwritten notes. I don't know if it's possible to flip that exhibit around.
What do we see there?
So these are the notes. It says Elk Rapids PD. 2 miles, 2.5 minutes. Everything else, 20 plus miles out.
Okay. During the audio clips that we heard earlier, did Mr. Molitor mention discussion about local police departments?
Yes, you did.
Okay. Can you turn to proposed exhibit number 145, please?
I have it here.
What is that?
This is a surveillance photograph taken of Eric Molitor inside the Oasis Red Bull Tavern.
Okay. And move for admission on 145, please.
Violation. Sure. Agent, you took a picture.
A member of our surveillance team.
You didn't take it.
That's correct.
So you don't know if it's in the same, if not substantial, something like was taken.
When we take pictures, there's
You don't know.
Hey, no.
Hang on.
Yes or no?
Hang on. You can answer the question. Do you know whether or not it fairly and accurately depicts?
Yes, it does fairly and accurately depict the scene.
How do you know? Did you take the picture?
I've been to the Oasis.
Did you take the picture?
I did not take this picture.
Judge, this evidence is not properly laid the foundation to prove this witness, because he has no personal knowledge of whether or not the picture has been taken at the Oasis, whether or not it has been altered, or if it is in the same, if not similar, substantially similar to the one that was taken, or by whom took it. Therefore, he is not a proper witness.
Mr. Whitmer?
I agree with all that. I just want to know who took the picture and wasn't from the industry.
Well, the kid wasn't the photo, the person who took the photo, it's the substance. The issue is whether or not fairly and accurately depicts that, which has been called into question. Mr. Ralston, if there's additional foundation that you want, questions that you want to ask, and then I'll go back to the other concerns against the objections.
Can we approach?
Mr. Alderman, back to you.
Sure, Judge. I think this really goes to weight versus admissibility. He's indicated there's a surveillance team inside. He's indicated who the subject is, the photo. I'd move for its admission.
Okay, Mr. Montier,
No comment, thank you.
Mr. Sacks.
Judge, we just remove our foundation issues as well as extend our written objections.
Great, Mr. Barnes.
No objection.
Hayden, where were you when this photo was taken?
I was on surveillance about a half mile away.
And who took the photograph?
A member of our surveillance team took the photograph. I don't know which agent it was. I believe we sent 2 agents in there to get eyes on.
Was there audio monitoring of this?
Yeah, so I was live monitoring inside I was live monitoring Dan while he was inside. I was listening to the activity going around with the patrons, and the surveillance team went in there to get visual confirmation of what was going on while I was live monitoring it.
Based on the testimony and the monitoring that Agent Apollo was doing and what's depicted in this photograph, the court is satisfied that in terms of admissibility, the requirements have been met. 145 will be admitted. In terms of the objections raised, they are noted for the record, and any such information can be taken as to data. Mr. Ralston.
Thank you, Judge. Adam, what do we see here, Agent Impla?
This is Saturday afternoon in Antrim County at the Oasis Red Bull Tavern, and this is Eric Molitor right here over this unknown gentleman's shoulder.
Okay. If you can look at proposed exhibit 146, tell us what that is.
This is another shot from our surveillance team inside, and it's got Adam Fox, Eric Molitor, and CHS Dan. Another picture inside the Oasis Red Bull Tavern from the daytime surveillance.
And what are those 3 gentlemen doing when the photo's taken?
They're talking at a table.
Okay. And I'd move for admission of 146, please.
Mr. Montier.
Yes, Your Honor.
Mr. Sacks.
Please stand on the written objections.
And Mr. Barnes.
Check to the characterization that they're talking at the table. This is actually the first time I've seen this. Both the online and also the email first. With that said, I see it every day in my mind. The only objective is characterization of talking. We have no objection coming in shows where people were seated.
And this was part of the discovery that was in the exhibits that were delivered on August 7th, Judge.
Exhibit 146 will be admitted. The objections, which I assume are the same for 145.
What do we see here?
So right here, where the laser's on, that's CHS Dan. Right over his left shoulder of CHS Dan is Eric Molitor. And on the right here is Adam Fox with his elbows on the table.
Okay. You can look to proposed exhibit number 147. Can you tell us what that is?
Yes, this is another surveillance photograph of Eric Molitor, CHS Dan, and Adam Fox leaving the Red Bull Tavern.
Okay. And generally describe what's going on.
The 3 individuals are walking out towards CHS Dan's truck.
Okay. Move for admission of proposed exhibit 147, please.
Mr. Lindsay? Mr. Seibert?
Please stand on the written objections.
Mr. Barnett?
No objection.
147 will be admitted.
Thank you. Agent, are you familiar with, well, 1 minute if I may, Judge. Exhibit 150 that's already been entered, describe what that is for us again.
That's the surveillance video in which Eric Mueller took, in which it's the slow motion video where they go by the governor's residence.
Was that taken before or after their visit to the Red Bull Oasis Tavern?
It was after they park the tavern here, they go back to look at her place again.
Okay. Are you familiar with proposed exhibit 148?
Yes,
Tell the ladies and gentlemen of the jury what that is.
this is a video taken by Adam Fox just before the video that Eric Mueller took. And it's another video. However, that one did not capture the governor's residence.
Is this video taken, if you know, before or after the visit to the Oasis Red Bull Tavern?
It's after.
Okay, and proposed exhibit number 148.
Yes, it's after Oasis Red Bull Tavern.
Okay, and this video does not capture the governor's property, is that correct?
Correct.
Move for admission of proposed exhibit 148, please.
Mr. Lindsay?
Judge, please stand on the written objections. If one puts out.
No objection.
148 will be admitted.
148, 148.
Houses in the woods. Get that area. Or south. All right.
It missed the governor's property, correct?
Correct.
Okay.
Correction, I think that was taken, that was not there, right? I think they indicated it was that box, but it's not directed to the left. Doesn't do it, didn't show it when the request was based on the fine in 148.
Another talking objection, Judge. Thank you. I'd like to draw your attention, please, to proposed exhibit number 153. Can you tell us what that is?
Sure. 153 is a photograph taken by CHS Dan, and it's at the boat launch, so the north side of Birch Lake, and it's Adam Fox looking south across Birch Lake towards the governor's residence.
Move for admission of 153.
In terms of the accuracy of the photo, Mr. Ralston, are there any additional questions?
Sure, Judge. Tell us, if you will, who took the photo?
CHS Dan took the photo, and
Okay.
then
Go ahead.
he provided it to me after I debriefed with him and collected his recording device.
Okay. And did that photo go into evidence?
Yes,
Turned over to defense and discovery?
yes.
Okay. Move for admission of 153, please.
Mr. Lindsay? Mr. Seibert?
Judge, please stand on the written objections. And we also move for the lack of foundation.
Mr. Barnett?
Just a quick one there. This shows there, excuse me, Adam Fox and Adam Fox on the
That's correct.
by the water.
Yes.
Mr. Wilson, any additional questions as to the accuracy of this?
No, thank you, Judge.
Great. Crisis returns.
Thank you, Judge. Have you been to the boat launch there on the north end of Birch Lake?
Yes.
Okay, and is that an accurate depiction of it?
Yes.
I'll renew my motion, please, Judge.
Review the foundational objections. Usually got lake that any of them. We don't know which lake it is, we don't know when it is, we don't know the time of day, we don't know any information. This individual did not take a picture of our witness.
This is taking quite some distance away from where the truck was, is that correct, sir? You can tell me how far that is, the estimation. In the truck was parked, you know?
Yeah, no, I cannot tell you where the truck was parked.
Thank you. Nothing else? Fine.
Well, unfortunately, based on the testimony provided, I guess you feel like it's familiar in the area, and his knowledge of this scene specifically, there having a sufficient foundation laid, and for the fire.
What are we looking at here, Agent Empla?
This is the boat launch on the north side of Birch Lake. And then this is due south, this direction, and then the governor's residence is over here on the west side of the lake.
Okay. Are you familiar with, and who's the gentleman there in the picture, if you can tell us?
This is Adam Fox.
Okay. Proposed exhibit number 154. Can you tell us what that is, please?
This is another view from the boat launch. It's from the similar location. This time Adam Fox is standing up and he's using his hat to screen the sun as he looks across the lake.
Same question. You've been to the boat launch?
I've been to the boat launch, and this picture was also taken by CHS Dan and provided it as evidence following the surveillance.
Okay. Picture accurately depict that area?
Yes.
Move for admission 154, please.
Mr. Johnson?
So we stand on the foundation as well as our written objections pointing out that CHS Dan would be proper witness.
Question, if I may? Yes, sure. Is this picture taken in close proximity to 153?
You're talking in time or in distance?
Distance, sorry.
Oh. It's a matter of feet.
Objection.
As well as the court indicated previously, the foundation issues that were satisfied, perhaps additional more testimony, but of course, mind a proper foundation taken late, 154 will be.
Thank you. Mr. Empla, if you can turn to proposed exhibit 155, please.
I have it here.
What is that?
This is a view from generally the same spot at the boat launch. So this is taken by CHS Dan, and it is a view looking west along the shoreline.
Was this taken at the same time as the last two exhibits? And when I say the same time, I mean within the same, certainly the same day, within the same time frame as the first two pictures?
It was, but sorry, I want to make a clarification. Dan did not take this photograph. I found this on Adam Fox's cell phone.
Okay, and this is proposed exhibit number 155, is that right?
That's correct.
Okay, and move for admission of proposed exhibit 155, please.
We stand on the written objections as well as the foundation issues.
Mr. Barnett?
Relevancy of this picture, where it's taken from. It doesn't show anything to become jury.
Mr. Walton, as to relevance for this particular photograph.
The next line of questioning to the witness is going to be about Mr. Fox's plan for how he was going to approach the governor's cabin during the attack.
The court will conditionally admit 155 subject to the additional testimony. Which is proper.
Please. Did Mr. Fox ever express an idea of how he was going and his team were going to approach the governor's property?
Objection to meeting.
Mr. Walton?
How does that suggest the answer would be my question?
Sorry, can you repeat the question?
No problem. Did Mr. Fox ever express any ideas about how he and his attack team would approach the governor's cabin?
Yes, they were going to approach via water from this boat launch here, and they were going to try to find boats that weren't marked that they could abandon. So they talked about stealing boats that were already available on the shoreline. And then this is a photograph that we found on Adam Fox's phone as he referenced these boats to CHS Dan from the boat launch.
Okay, thank you.
Sorry, Mr. Walton, that also addresses the court's question as to relevance. So again, 155.
Thank you, Judge. I'd like to draw your attention, if I could, please, to proposed exhibit number 156. Are you familiar with that?
I am.
What is that?
This is a screenshot, which was found on Adam Fox's phone. And the screenshot is a pin drop at the boat launch. And the screenshot includes the Birch Lake area and 31, Highway 31.
I move for admission of proposed exhibit number 157, please. I'm sorry, 156. Thank you.
I'm sorry, there's also a pin drop of the Oasis Red Bull Tavern area as well.
Okay.
Mr. Nunnally? Mr. Simon?
Could we stand on the written
Mr. Barnett?
Whose relevance is to the pin drop and this plan was to go on the lake side and the street side? Is that what this is proposed?
Yes, the attack plan was to come in through the boat launch, through the water, and attack the protection detail from the water.
Each side.
The entry point is from the boat launch, however you want to call it.
Any objection to the admission of 156?
It's limited. Yeah, I have no objection.
156 will be admitted.
Okay. Show us those two locations that you described.
So this is the boat launch pin drop from Adam Fox's phone, and this is the general location there, the Oasis Red Bull Tavern.
Okay. Proposed exhibit number 157. Are you familiar with that?
Yes.
Can you tell us what that is?
This is a photograph taken by the FBI surveillance team at CHS Dan's Eric truck with Eric Molitor and Adam Fox as it passed the Elk Rapids Police Department on the way out of town as they were reconning the location of the first responders.
Is this, if you know, is this picture taken before or after Eric Molitor talks about trying to find where the local police departments are?
So it's after where he talks about the local police departments.
Okay, move for admission of 157, please.
Any additional questions as to the accuracy?
Oh, yeah, you've been down to Elk Rapids and been to the police department, is that correct?
Yes, sir.
And does this accurately portray that scene?
Yes, that's Dan's truck as I saw it that day during surveillance.
Okay.
Mr. Nunnally? Mr. Sadler?
Could you just stand on the objections?
Mr. Barnett?
One question, one, Mr. Wilson. This also came after, you said 3 miles, those are handwritten map, it's a 2 miles for PD, and 3 minutes. But this, that Adam wrote in the tavern, I assume this picture was taken after Adam wrote that information down on that handwritten map as well.
I'll kind of step through that one by one. The handwritten, I'm not going to quibble over whether it's 2 miles or 3 miles. And this occurred after the lunch at the Red Bull Tavern in which the map was drawn. Is that what you were asking?
Yeah.
Okay.
Any objections to submissions?
No, Your Honor.
157 will be amended.
What do we see here, Agent Employ?
So this is CHS Dan's truck, and then this is the location of the Elk Rapids Police Department.
Let's move, if we could, please, to proposed exhibit number 161. Are you familiar with that?
I am.
And what is it?
This is a Google Earth map that I created with distance location from the boat launch to the governor's residence, and then from the governor's residence to an extraction point to Lake Michigan.
Why did you put the extraction point there on Lake Michigan?
Because on the way out of town, CHS Dan, Adam Fox, and Eric Molitor drove through a neighborhood where they could see an extraction point and discussed that being the place to take her out to the big lake.
Okay. Move for admission of 161, please.
We object on foundation, speculation. The fact that not in evidence, this is just the agent's opinion as to what's taking place.
Mr. Sires.
Yes, we object also to information as well as the dictum that is put on the exhibit. We've asked that any dictum be stricken from the posted exhibit. Dan, we have seen objections.
We object again that Eric Molitor never discussed this. The case will show a challenge to show a date. This is described wrong.
Agent, so the point that is marked here as the proposed point on Lake Michigan that you referenced, was that one that was selected by you, or was that a specific point of date?
So following the surveillance, CHS Dan brought me out there and showed me the point that they were referencing. Showed me the spot that they drove through that Adam Fox noted to him, which was then later referenced by Adam Fox to the Null brothers in the car when he told them.
The Null brothers run this car, Judge.
Well, the court will not admit Exhibit 161 in its current form, given the what is referred to as dicta, that can be title of the document. If perhaps the map in and of itself, based on the testimony, were tried to be admitted according to that decision.
Understood. Thank you, Judge. 162, Agent Employ. Can you tell us what this is?
Yes.
Go ahead.
These are the Google searches found on Eric Molitor's phone pursuant to a search warrant.
And what date were these searches made?
They were made on August 29th, 2020.
Okay. How many searches make up this exhibit?
6 separate searches.
Okay. And what are the searches for?
Objection, calls for speculation.
The difficulty is in answering your question, it comes when you get itself. Agent, in a general sense, what would the substance of these searches?
In a general sense, all the searches are for the address.
No, sir.
Please stand under objection.
We would object as to relevance. Mr. Molitor did not discover any evidence. He explained it, they did come in, but they're not open. He didn't discover anything. He didn't provide any respect for that. he's got a reason for what he did. And he said it does speak for itself when you plug in here. But it's not relevant. There's, we moved here toward finding a cottage. It just doesn't, it's not relevant.
Well, court does find that there is a relevance to the tendency to approve or disapprove, and so the trier fact may find this assisting them in doing that based on the nature of the searches, whether it was successful or not, and also help them prove the negative. So it does have a tendency either way. And based on that and the criteria as has been qualified and testified to application 162 will be.
Let's work through these, Agent Empola. If you can enlarge the first one, please, Adam. What do we see here?
So right here on the left, this is what Eric Muller typed into his phone, Governor Whitmer cabin address.
And obviously the URL code is in the next column, is that right?
Yes.
Okay, and what do we see in the next column, last visited? What's below that?
This is the time and date stamp. Of course, it's in UTC.
Okay, now the UTC, remind us what that is again?
That's Greenwich Mean Time.
And
It's -4 or -5 hours.
okay, and in this particular instance, it's also designated PM, is that right?
Correct.
Okay, so we would be subtracting, depending on daylight savings time, 4 or 5 hours off that, is that correct?
Correct.
Okay, can we go to the next search that he made, please? What do we see here? And these are in descending order in terms of chronology so far.
Correct.
Okay. Go ahead and tell us.
This is another search, Governor Whitmer cabin address. There's the URL, and then this is 5:49 p.m. UTC.
Okay. That would be a second search he made then, is that correct?
Yes.
These are separate searches, is that right?
Yes.
Okay, go on to the third one, please.
This is a search. The term is Governor Whitmer cabin address, and it's 5:48 p.m. UTC.
Okay. The next one, please. What do we see here, Agent Empola?
The search is a little bit different. It's Gov Whitmer addresses, Antrim County Cottage and Boat Controversy, 9 and sign 10 News. And it's from 5:47 p.m.
Okay. And the next one, please, Adam.
This search is Governor Whitmer cabin address, 5:47 p.m.
UTC 10.
Yes, sir.
Okay. And the next one, please.
There's a similar search, Governor Whitmer cabin address from 5:47 p.m.
Okay.
UTC.
And I think that concludes it. Is that correct? Yeah, thank you. Okay.
Judge, we have a foundation issue here. You're looking at the times, show 5:47, 48, and within 2 seconds, you have somebody typing in an hour full search string. I don't know about you, Judge, but when I type things on the phone, it takes me more than 2 seconds. And it's on the 9th, the 8th, the 7th, and then you get a string of 24 seconds. And then you get a string of another 18 seconds. And then it just seems like these are really quick. You're within 2 seconds typing these strings. I believe there's a combination issue here, Judge.
Mr. Wilson.
Other talking objection, Judge? No.
Well, the objection is noted for the record. The document is submitted. It does include the times, self-indicated to the jury, and the times are what they say. Documents.
Thank you.
About to enter a new area judge. Not sure if you want me to dive in and keep going.
Well, I'll tell you what, ladies and gentlemen, it's been a nice long hot Monday for everybody. It's the end of the weekend, so that's here for today. We'll have you back tomorrow morning at 9 a.m. Just to give everyone a heads up, I am considering switching my start time to 8:30, getting our pace today. But we'll make that determination either necessary tomorrow morning. We'll still be in 9 o'clock. Okay, all rise for the So, Mr. Arden, can you just remind him, I forgot to tell them, just to leave the paperwork upside down, just as they have in the past. Any objection to Mr. Arden?
Not at all.
The record can reflect, I don't know how to see. I'm just trying to say, Mr. Wilson, anything before we break for the day?
No, I second your idea. It's 8:30 start time, so.
We're going to start at 9 o'clock tomorrow, but we'll see one. Mr. Dunn, do you have anything else to do?
No, thank you.
Mr. Simon?
No, thank you, Judge.
Mr. Barnett?
Just going to help everybody, and if there was a question on the extraction, to have some numbers and names, where's put in, you go to that, and then put in something, you can see 8, 9, and 10, those, click on that, then when you go back, I think it's showing that, oops, we're going back to the thing, so it's that explains the extraction versus the help. Changing out and explain this, we don't have